Joseph and Government People, Your Honor.
Assistant Public Defender Hannah Apple appearing on behalf of Ms. Johnson. Ms. Johnson, can you state your name for the record?
Valerie Johnson.
Your Honor, I have an application pending to schedule a meeting with Ms. Johnson, so I'd ask for an adjournment for that purpose.
Without objection, how much time? You have the application.
The application is pending, but I already have, I guess, my video visits approved. So once, it shouldn't be very long, I don't expect. That makes sense.
Okay, I believe that. All right. Probable cause conference will be here on September 4th,
Thank you.
2025, 9 a.m. Bond will continue. Thank you, Ms. Johnson.
Thank you.
Senator Gregg here.
Really? No, go ahead. I'll wait. You got everybody? Court does call the case of the people versus Michelle Lovaz.
John Shea, Your Honor, with and on behalf of Ms. Lavaz, who's approaching.
Morning, what's your name?
State your name for the record.
Michelle Lavaz.
Thank you. All right, what are you doing?
Your Honor, the defense has been awaiting supplemental medical records for quite some time. Medical records take a long time to obtain. My understanding is the prosecutor's office has them. They will be tendering them to us. We will be tendering them to others who need to review them. I'm going to be out of the country between August 31st and September 19th, so we're requesting a PCC until after that.
Since September 19th.
Yes, sir.
You come back. I can do September 25th or October 2nd.
Your Honor, September the 25th will work just fine. At the 22nd, excuse me one second, Your Honor. Your Honor, it's September 25th for the time being. We may have a conflict with that, but if we do, we'll contact the court. I know I have a conflict on the 2nd.
Hearing no objection, probable cause conference, September 25th, 2025, 9 a.m. Bond continued.
Thank you very much. Thank you, Your Honor.
Court calls case People versus Samuel Klosky.
And then on behalf of the people, Your Honor.
Everybody see Mr. Jerkis?
Yes.
I'm sure he did.
I go fine.
Where is he? I realize, Ms. Cannon, you are trying to stand in my eyesight, so I know that you're actually here and we're waiting on somebody else. No, never mind. You don't have to say anything. I'm just saying, I get why you're there.
My apologies, Judge.
Your name, sir?
What's your name? Samuel Klosky.
Thank you.
Your Honor, we are asking that this matter be set for preliminary exam.
All discovery complete?
To my knowledge, yes.
People have their witnesses available the 2nd.
We'll do our best, Your Honor.
Preliminary examination in person, September 2nd, 2025, 9 a.m. before Judge Fleischer.
Thank you, Judge. Thanks, Your Honor. All right.
Bond continued. Court calls case People versus Eric Lightheart.
Joseph and Government People.
Good morning, Your Honor. Christopher Shemke appearing on behalf of my client who approaches.
Your name, sir?
Eric Lightheart.
Thank you. We're doing, you're seeking an adjournment?
Yes, Your Honor. don't hear that go off.
That objection, probable cause conference will be adjourned to September 2nd, or September 4th, excuse me.
Your Honor, if possible, I was respectfully requesting consideration for the 18th of September. I fully expect the matter to find a resolution. I do not see this matter being set for an exam.
5 weeks out.
But this would, I wouldn't be seeking any additional adjournments.
Any objection from the people? September 18th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor. Thank you.
Court calls case People versus Kyle Beckerman.
Good morning, I'm pleased Honorable Court, David Burgess on behalf of Mr. Beckman. We got our discovery is complete. We're requesting exam on this matter.
Your name, sir?
Kyle Beckerman.
People have their witnesses available the second. Preliminary examination in person, September 2nd, 2025, 9 a.m. before Judge Perry. Bond will continue. Court calls the case of the People versus Latana Marie. I'm sorry. Yeah, Latana Marie Lee. Let's see, get that wrong. Naya Lee. They have it. They have those.
Andrew Childers is on behalf of the People. Good morning, Your Honor. Sam Bernstein with on behalf of Ms. Lee. Ms. Lee, could you please state your name?
Naya Lee.
Your Honor, we're asking for an adjournment. There's some discovery that still needs to be produced and we're working on a resolution. So a lengthier adjournment would be appreciated, Your Honor. Respectfully requested.
The 4th.
Like a 30-ish.
Pardon?
You said to the 4th, Your Honor? Could be a little
If
bit
I'm giving suggestions. Go ahead.
like the 18th, Your Honor, please.
18th, why? This is 5 weeks out. The other one was a retail fraud. I don't even understand why we sent that out 5 weeks. And this is,
Yeah, I guess that is a little bit lengthy. September 11th, Your Honor.
September 11th, 2025, 9 a.m. Bond continue. Court calls the case of the People versus Christopher Decker.
Good morning, Your Honor. J. Grant Miller, P58658, on behalf of Mr. Decker, who approaches. Please state your name.
Christopher Decker.
All right, you're requesting a forensic exam.
Yes, Your Honor. I met with Mr. Decker. There were some concerns raised during our meeting Saturday, so we're requesting a forensic exam. I've received the paper discovery from the People. The prosecutor also has provided me the email address, and I already sent over a request while waiting to be called for the digital discovery. I think the only holdup is how long it'd take to get the forensic center to see my client.
Forensic examination evaluation is ordered. I'll set a competency here and give me 90. We'll move it up. Yes, sir. November 13th, 2025, 9 a.m.
And Your Honor, my understanding is I don't believe bond's been addressed in this, and we just asked the court to reserve that. There's a revoked bond from a case that's already been bound over to circuit court. So I don't believe any of this time is counting on this case, but we just didn't want the court to deny bond or take any further action until we get a response back
He's got a 25,000 cash shirt.
on this case. Thank you, Your Honor.
Thank you. Bond will continue. Court does call the case of the People versus Carlton Cross. Mr. Feaster's case.
That's not the name. He said anything in pot. He didn't say anything about this.
the mic on.
Lauren Brown, Deputy Chief Public Defender, placeholding. Sir, can you state your name, please?
Yes, sir. Cross and Deion Cross.
Thank you.
Really, Judge Fleischer, Assistant Public Defender.
Thank you for joining us.
Apologies.
What are we doing on this?
Thank you, Judge. I've been trying to work with the prosecutor to receive an offer on this case. I believe it's the first PCC. We have not yet received that offer. I will request a brief adjournment to see if there is an offer we can possibly get to resolve this.
That objection, August 28, 2025.
Thank you, Judge.
Continue. Thank you, Mr. Cross.
And sir, Judge
I'll come
Simpson.
down and talk to you, Mr. Cross.
Okay, and Judge Simpson, and I've already, among other cases, I've already been released to treatment, and I'm just waiting for Miss Sarah at correctional service to come down and talk to me.
Okay, I'm sure that'll happen. Okay, and if there isn't an order on this case, they can prepare an order and I'll sign off so that this case doesn't hold you up, okay?
All right, thank you so much, sir.
Thank you.
Have a good day.
You do the same. Court calls the case, People versus Delorean Duro. So.
Joseph, you know the people, Your Honor?
Morning, Your Honor. Sam Bernstein with on behalf of Mr. Duhall. Mr. Duhall, could you please state your name for the court?
Delorean Duro.
Sorry, apologize. Your Honor, two things. First, I had spoken with Mr. Duro about setting this for exam, but in reviewing the discovery after we spoke, I realized that there's some more discovery that I would need before setting it for exam, so it's not there quite yet. I still have to fill out a green sheet for Your Honor, but I'm asking for a short adjournment to do that, please.
August 28th, 2025, 9 a.m. I'll need a green sheet. Bond will continue.
Judge, I was hoping to address bond for Mr. Duro. Your Honor, Mr. Duro suggests that he has a number of community supports and stability of the community that would allow him to be monitored safely. He does live with his father in Southgate. His father is a business owner and he works for him. He is being groomed to take over a management position there, and he's made a lot of strides there. He also works full-time at McDonald's, 10 to 6 weekdays, Your Honor, and he has a 4-month-old baby at home. He is asking the court's consideration for bond review.
Response. I'm sorry, I did not hear any of that last part.
I believe, Your Honor, the bond has set is appropriate to the charges that are facing. But given the fact that this defendant is charged with armed robbery, I think the bond is appropriate as set for the court to make further determination.
At this point, what I'm going to do is I'm going to deny the motion to modify the bond in this case. The bond will continue. However, Mr. Brochet, if you'd like to file a written response so I can get more information, since I didn't get any for the people, I'll be more than happy to consider it.
We'll do that, Your Honor. Thank you.
Court calls case People versus Alexander Sanchez Garcia.
Good morning, Your Honor. Nicholas Monterez on behalf of Mr. Alexander Sanchez Garcia, present to my right. Mr. Sanchez Garcia, can you state your full name for the record?
Alexander Sanchez Garcia.
Thank you. You're requesting an adjournment.
I am, Your Honor, and I spoke with the people before stepping up to the lectern here. If the court would like more information, because the green sheet is a bit vague, then I'm happy to give it, but the people and I, we're asking for 3 to 4 weeks, Your Honor.
That objection, probable cause will be adjourned September 11th, 2025, 9 a.m.
Thank you, Your Honor.
Bound continue.
Thank you, Your Honor.
Court does call the cases of the people versus Todd Reeberg.
Andrew Childress, people. Carl Burdell appearing on behalf of Mr. Reeberg in the case ending in 5649.
And good morning, Your Honor. Laura Yagi, Assistant Public Defender, with and on behalf of Mr. Reeberg in all his other matters. Mr. Reeberg, could you state your name for the court?
Todd Reeberg. Thank you.
And Your Honor, I would ask you to approach on these matters.
Come on.
Thank you.
Judge.
All right, record should reflect we had a bench conference in this case. You're seeking an adjournment.
Yes, Your Honor.
Yes, Judge. Because he's still awaiting potential release to treatment.
Yes, Your Honor.
I can't.
What, the 4th or the 11th, Ms. Young?
Yeah, either works for me, Judge.
Either, Your Honor.
Did I ask Burdell? Did they say Ms. Young?
Oh.
Burdell thought I cared. No.
Probably the 11th, Your Honor. Thank you.
She's still doing great.
I am.
Probable cause in this matter will be adjourned to September 11th, 2025, 9 a.m.
Thank you, Judge.
Thank you, Your Honor.
Thank you, Your Honor. Keep your head up top. Thank you.
Court does call the case of the people versus Nolan Hearns.
Your Honor.
Good morning, Your Honor. James Feitelski appearing with and on behalf of Mr. Hearns. Can you state your name, please, sir?
Nolan. Oh, he just has.
Yeah. Your Honor, I'm asking for a brief 1-week adjournment for the video discovery, which I believe is forthcoming, and set this for PCC out at the next available date.
Probable cause conference, August 28th, 2025, 9 a.m. On continue.
Thank you very much, Your Honor. August 20th.
Okay. The court calls the cases of the people versus DaVon Langford.
And then on behalf of the people, Your Honor.
Sherilyn Foster Tucker on behalf of DaVon Langford.
DaVon Langford. Thank you.
Your Honor, I am just jumping in on this case. I'm just requesting a brief adjournment to get discovery and review it with my client.
Probable cause conference, August 28th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court does call the case people versus Tesa Michael Tesarian.
Joseph and people, Your Honor. Good morning again, Your Honor. James Feitelski appearing on behalf of Mr. Tesarian, who is approaching. Come on up, sir. Please state your judge.
Tesa Michael Tesarian.
I'm sorry.
My name is Tesa Michael Tesarian.
Your Honor, we are simply asking the court to set this for preliminary examination. I believe I have all of the discovery, and then I can address the community corrections issue.
Why don't we address the community corrections violation now?
Yes, Your Honor. There is a slight language barrier with my client. He does have a green card, but he's from the country of Eritrea, I believe it is. He tells me that he didn't receive any paperwork when he was released from custody, so he didn't know exactly what to do. When I got the notice of the violation from Community Corrections, I advised him to go over there. He said he did go over there twice yesterday, asking to be enrolled in the intake process. He said that they told him they didn't have any paperwork for him to do that. So he's happy to do that right now.
That's not true.
I don't think there'll be any problems.
It's not true. There's
Okay.
paperwork over there. I can see the paperwork over there. And if they didn't have paperwork, they wouldn't have sent the bond violation. He's not telling you the truth.
I did.
Well, I apologize, Your Honor, on his behalf. He tells me there shouldn't be any issues if the court wouldn't mind passing it for him to do.
When did he say he went over there? Because I'll call right now.
Yesterday.
Yesterday afternoon?
Yeah.
They wouldn't have. It's not true.
I did.
I can tell, because I got the bond violation here from me.
Okay. This is his first experience on this level with the legal system. So I would ask.
Probable cause conference will be adjourned August 28th, 2025, 9 a.m. At this time, the defendant's bond is revoked. Defendant's remanded. Are they ready? Court does call the case People versus Carlos Cell.
We're hearing on Mr. Self, who's approaching the podium as we speak. Carl, once you get up here, please introduce yourself to his honor.
Carlos Cell.
Thank you, Your Honor. I had previously represented Mr. Self in the matter ending in 5140. Late yesterday, I was just appointed to his other matter, 5186. We are asking that both matters be adjourned in order for me to review discovery and work on a global resolution with the people.
Probable cause conference in these cases will be adjourned August 28th, 2025, 9 a.m. Bond continued.
Thank you, Judge. Defense may be heard as to bond.
Go ahead.
So, Your Honor, Mr. Self had previously received a bench warrant in the case ending in 5140. That's because he was in the hospital with extremely high blood pressure. He tried to leave. He tried to get his doctors to let him go, but the doctors said, well, you can stay here or you can go to court and have a stroke due to his extremely high blood pressure. So he opted to protect his health and stay. So unfortunately, he was predisposed. He did have his intake paperwork. I asked him to provide it for me, but unfortunately that was lost when your apartment flooded, was it?
Yeah.
So his apartment flooded and destroyed a lot of his belongings. So unfortunately, we don't have documentation for the court. He is also interested in.
Does that explain the cocaine use during July?
I don't believe that would be related, Judge, to that particular issue. But we have reached out to Sarah Stewart in the jail about getting into Dawn Farm in-jail treatment program. Mr. Self is a business owner. He owns a barbershop. He's eager to get back to work. He has 3 employees who rely on him for their livelihood, in addition to his own livelihood at the shop. The shop is currently closed and idled while he is in custody. So we are asking that he be released to be able to return to being a productive member of community and a job provider for the local community. And so we are asking for a PR bond on these matters.
I don't need a response from the people. His bond will continue as previous, as I've said it. In this case, motion for bond reduction is denied.
Understood. Thank you, Judge.
Court does call the case of People versus Vincent Lambert.
Morning, Your Honor. Public Defender Lamia Gresham on behalf of Mr. Lambert.
Mr. Lambert, can you state your name, please?
Vincent Lambert.
Thank you, sir. What are we doing?
I'm requesting an adjournment. Your Honor, we are missing some video. I did re-request it yesterday, and as of this morning, Mr. Childers did advise me that it should be released, so we just have to extract it and watch it.
Give you my next available date, August 28th, 2025, 9 a.m.
Thank you, Your Honor.
What was your name,
Thank
ma'am,
you.
so I can call you and ask you a question?
He's talking to you.
It's Miss Saab. Like the car, SAAB.
Ms. Saab, thank you very
Saab,
much.
not Audi. Trying to make that clear. Court calls the case, People versus William Bastable.
Joseph, people you're on?
Mr. Genoa,
Time be next door.
really? Didn't do me any good.
Hello. I've been. How are you?
Oh, do you know what you're doing on your case today? If you adjourn, you said.
What's he saying? He might adjourn on video.
Video, okay.
Sorry, Your Honor. Assistant Public Defender Ben Denowith on behalf of Mr. Bastable. Your Honor, the defense is asking to adjourn a week. We've not received the video discovery. My emails of Friday and Monday were not returned. We cannot conduct the preliminary exam without the video that is referenced in the police report. So we'd ask to adjourn for a week. I do have the form in my bag.
Well, I'll need the form.
Okay.
Without objection, probable cause conference, August 28th, 2025. 9 a.m. Bond will continue. Court does call the case, People versus Tanya Hall.
Good morning, our object on behalf of Ms. Hall,
Tanya Hall.
Judge, I've just been speaking with the prosecutor in this matter. I believe we're going to work out an agreement where she's going to be allowed to plead to a misdemeanor. My understanding, we don't have a plea form today, so we're asking for a very short adjournment so we can do that.
Has she been counsel approached?
We're asking if we could set this matter for the 28th.
All right. I will adjourn this matter out August 28th, 2025, 9 a.m. Bond continued. Okay, Ms. Hall, we'll see.
Yes, sir. You can get back on the 28th.
Yeah.
Okay.
Court does call the case, People versus Brian Gerard.
Assistant Public Defender, let me stop on behalf of Mr. Gerard. Your Honor, we are asking to set this for preliminary exam, and to my knowledge, discovery is complete.
All right, sir, your name?
Brian Gerard.
People have their witnesses available the second. Preliminary examination in person, September 2nd, 2025, 9 a.m. before Judge Fleischer.
Thank you, Your Honor.
Thank you.
Thank you.
Court calls the case of the People versus Ronald Lucky.
Joseph, people you're on?
Morning. Judge, in this matter, we'd like to set this matter for a preliminary exam.
Your name, sir?
I'm Ronald James Lucky.
Discovery is complete, Mr. Khalo.
Yes, Your Honor.
People have their witnesses available the second. Preliminary examination, September 2nd, 2025, 9 a.m. That is before Judge Perry.
Judge, may I address an issue? Mr. Lucky was staying where the incident, the allegations against him. He was running a space at 1074 East 4th. He's not allowed to go there. All his worldly possessions are there. He has tried numerous civil standbys. He said he even got a court order that he could get his belongings. Can you be of any assistance, him getting his property from there?
I'm not moving anything, if that's what you're asking.
Pardon me? No, I'm not asking you to help move them. No, not, you know, that. Judge Oldham.
Well,
Ordered it.
who ordered it?
the one that let me out on bond, I believe Judge Otis, they wrote it down on a post, you know.
It's a Odetella.
I'm
It's a
sorry.
magistrate.
I'm sorry. I didn't have my
I'm
glasses.
gonna tell him you called him Otis, though.
Sorry.
Funny.
Ron,
Right.
Like the elevator. You have an order that allows civil standby.
He said he was issuing a written order for me to have access to my property. That's what he said on Zoom when I got bonded out.
Has he issued it?
He said he did. I was in custody. I didn't have a pen, a paper, a case number. I have nothing.
Would that be reflective in the file, Your Honor?
I don't see an order. Mr. Khalo, if you prepare an order permitting civil standby to that address to retrieve his property, I'll sign off on it. I don't know.
Okay.
Sure. Nothing. Huh? Sheriff's done nothing. I've been there more than 10 times with the owner. There's witnesses.
We'll have a court order.
Thank you.
If he gets a court order, I'll sign off, sir. It'd have to be done today, otherwise I'm out for about a week, so.
I'll have it done this afternoon.
All right.
Thank you.
All right, thank you, Your Honor. Do we set the, oh yeah, we did say.
Also, the court
Wait a
keeps
minute, hold on.
mailing that address.
Okay, we're gonna take care of it.
September 2nd.
Yeah. September 2nd.
Court call stays. People versus Nathan Gabachi. Tell Otis he needs to do an order.
Andrew Childers, appearing on behalf of the people.
Good morning, Your Honor. Alex Warren, Green on behalf of Mr. Gabachi. Could you please state your name, sir?
Nathan Gabachi. Thank you.
Your Honor, at this time, we are asking the court to set the matter for preliminary examination.
Discovery is complete.
I believe so, Your Honor.
People have their witnesses available to second.
That's fine.
Preliminary examination in person, September 2nd, 2025, 9 a.m. before Judge Fleischer. Bonds will continue.
Thank you, Your Honor.
Court calls case People versus Ashley Nader.
And then on behalf of the people, Your Honor. That's Mr. Kill.
Yeah.
Morning, Your Honor. Rob J. Kill on behalf of. Judge, in this matter, we're asking.
Your name, ma'am.
Ashley Nader.
Thank you.
Nader, I'm sorry, Judge.
No, it's okay.
Judge. Sure.
That was to you or me?
I was just.
You were answering for me, Kilowatt?
Judge, I'm not sure where I am this morning.
Okay. All right. Well, that leads to confidence for your clients. Come on.
I'd like to.
People would have their witnesses available tonight.
Tonight.
Preliminary examination in this matter will be set in person September 9th. 2000.
I'm sorry to interrupt you, but I have probate matters, 3 evidentiary hearings starting at 9 o'clock. I don't know how long they're going to go in probate court. It's over money issues. I think they're going to be long hearings. Can we go out? Is it possible?
We're doing the 9th.
Yeah, I'd like to tell you I can't do the 9th. You're going to be going when?
Yeah, to the 3rd.
30th.
30th of August is fine.
No.
Of September?
Yes, sir.
I'm sure that's fine.
September 30th, 2025. That's at 12 noon. That is before me.
You're gonna go test. You're gonna take that.
What I'm gonna do is I'm gonna order that the defendant go over today. Ma'am, if I give you an ETG, there's some postings that indicate that you're consuming alcohol.
I'm not.
Probably shouldn't post it in the fashion those are posted. You need to go over and take an ETG test. I'm also going to order that the defendant is to be placed on a sober link unit pending further order of the court. Her bond will continue. However, with those in place, I will then allow the defendant to travel to Kansas City September 3rd through the 8th.
Yeah, Judge, the tether will be removed in silver link in place.
What gave you that impression?
Nothing really. I was asking.
Okay. Oh, that was a question?
I was asking.
That'd be a no.
The tether stays?
Tether stays.
Okay. Thank you for your consideration.
Yeah, I understand the disappointment, but she also left the state without permission, seeming not to understand that order, do not leave the state of Michigan. And I did not throw her in solely because of that. So she's lucky to be out and lucky that her only consequence of that has been a tether. Anything else?
No, Your Honor. Was she supposed to report back today after the
No, she doesn't need to report back today. She needs to go over, take the ETG test. Well, there'll be an order over there and she needs to pick up her sober.
Okay, thank you, Your Honor.
Court calls case People versus Khalo Haden.
Joseph and Government People, Your Honor.
And Assistant Public Defender Lamia on behalf of Mr. Haden, who is approaching. Mr. Haden, if you can say your name for the record.
Khalo Haden.
Okay, go ahead.
Your Honor, discovery is complete in this matter, and we would be requesting to set it for preliminary exam.
People have their witnesses available the second. Preliminary examination, September 2nd, 2025, 9 a.m. That is before Judge Perry.
Thank you, Your Honor.
That's in person. Thank you. Bond will continue. Court calls case People versus Dwight Williams.
Andrew Childers is bringing on behalf.
I'm here.
You know what? What's going to happen though is I'm going to call your case and you'll be nowhere to be found. Yes. The third 30.
Judge, can we pass the Mr. Williams matter? He had called me saying he was having trouble getting a ride from Detroit, but he promised me he'd try and be here.
Oh, he's not on a bus.
You being a considerate judge you are, I know you'll take that into consideration.
So this is just a delayed bench warrant.
Basically.
Yeah,
Yes.
okay.
Thank you.
Pass. Court calls the case People versus Curtis is it Moncanito? Moncanico?
Joseph and Government People, Your Honor.
Your Honor, Alexis Pluma appearing with and on behalf of Mr. Mechanical. Sir, could you say your full name for the record?
Curtis Mydro Mechanical.
Stop a little bit. Thank you. And Your Honor, we are requesting just a very brief adjournment. We haven't yet received discovery on this file. Our support staff reached out yesterday to the prosecutor's office, and I believe we should be getting that very soon.
August 28th, 2025, 9 a.m.
Thank you.
Bond continue. Thank you. Court calls the case People versus Derek Lovely.
Joseph and Government People.
Brandon Bird on behalf of Derek Love.
I was wondering where you were. It was not gonna be a complete day unless you showed up.
I was thinking the same thing about you, you know.
Your name, sir?
Derek Lovely.
Thank you. All right, you're asking for an adjournment?
Please.
4th or the 11th, sir?
The 4th, please.
4th. Probable cause conference will be set September 4th, 2025, 9 a.m. Bond will continue in this case.
You and your honorable court have a great day.
Thank you. You too. Court does call the case of People versus Michael McLean.
Alexander, on behalf of the people.
Lord Yagi, Assistant Public Defender, with and on behalf of Mr. McLean, who's approaching. Could you state your name for the court?
Michael McCartney.
Your Honor, in this case, I am respectfully requesting that it be set for preliminary examination. My information is I don't think there's any outstanding discovery.
People have their witnesses available to second.
We'll do our best, Joe.
And
Preliminary examination in this matter will be set September 2nd, 2025, 9 a.m. That is before Judge Fleischer.
thank you, Your Honor. May I respond briefly? My understanding is this is the only case that is holding my client. He does indicate that he has an alternate place to stay besides with the complaining witness. The date on this complaint is from June 1st. I don't believe there's any allegations of any like bond violations or contact. This was a delayed arrest. So Mr. McLean wasn't arrested at the time of the offense. He was actually in treatment, and then he was completed the first phase of treatment, was out, was not having contact with her, and then was arrested. So I think that shows that he can be out of custody and stay away from her, not have contact with her as he was for at least a few weeks before his arrest.
Your Honor,
Ms. Endo, yes.
I would be objecting to any modification of bond. The facts of this case are that he was released from jail on 5/28/25 and immediately went to her residence after being released. He was formally served on that date. And then on the preceding days afterwards, he was on her property, hiding on her property. When she would come outside, he jumped out and yelled, "Who do you have in your residence?" He then left and then began leaving her voicemails and calling her. A friend also saw him on her property. So I've had concerns given that. I also have concerns given that of his criminal history. He has a previous home invasion first conviction from 2007 and 2022 dismissed home invasion first, a 25 dismissed PhD second, and malicious destruction of a building. And he currently does have a hold outstanding for a domestic violence case with bond set at $500. So at this point, I would have concerns for her safety and communities, and I would ask that bond remain as set.
May I respond briefly?
Sure.
He was released from jail, but there was no contact order at the time he went back to her address. So I just want to clarify, it sounded really bad the way
Yes,
the
it did.
HPA.
You were being zended. Go ahead.
He was not aware of and not served the PPO until afterwards. So it wasn't like he went to her residence after being out of jail and being told to stay away from her.
So he got arrested on what?
If I can clarify, I'm not sure exactly if it's arrested. If I can clarify, he went to the residence on 5/28, was served the PPO that day, and then in the preceding days after he was served the PPO, told he should not get any contact. He went back to her property and then was also calling her. So he was violating that PPO after it had been served and he had been given notice.
Your Honor, he does dispute the timing of that. Obviously, I know this court is this is not a hearing date, so I know we can't get into the details. The missed call log and discovery shows 5/28 and not after. So we dispute that he made any contact with her after being served the PTO, but obviously that's the purpose of the exam. And so I just wanted to note that.
Motion for bond reduction is denied. Bond will continue. Thank you.
Thank you.
Court calls case People versus Akmed Ajabori.
Ready, Your Honor. Good morning, Your Honor. To you and your staff, Brian Berry, appearing on behalf of Akmed Ajabori.
Thank you.
Sir.
Ahmed Mohammed Al-Jabori.
Thank you.
Judge, today's the date and time scheduled for a PCC. We'd respectfully ask the court to adjourn to September the 9th if possible. The only reason is I have court almost every day.
September 9th?
Yes, Your Honor.
No,
Okay.
I need a green sheet.
I have a green
So
sheet.
you have, I can give you the 4th or the 11th.
Let's see.
You don't usually let people pick their dates and then you did it anyway and you picked the wrong date.
I did pick the wrong date. Do you have an afternoon docket on the 4th, Judge? I have a sentencing in Wayne County Circuit Court on a murder case on the 4th. And the 11th, I have a hearing as well. I'm sorry. I can.
No. Because so first of all, you being private counsel, chances are you're going to be in the afternoon anyway. I said everything at 9 o'clock, but I'm here all day. So I give you any of those dates, you will be set in the afternoon. Swidely, can you make sure counsel is set in the afternoon? Otherwise, we'll never get done with this case. All right.
Thank you, Your Honor.
I don't know. He was doing whatever he was. Which date do you want, sir?
September the 4th is fine in the afternoon.
All right.
Thank you.
Probable cause conference will be September 4th, 2025. I'll set it at 9 a.m., but you'll be in that block.
Thank you, Your Honor.
Notification. Thank you. Bond
Thank
continue.
Your Honor.
Thank you. Court calls case People versus Bandless Patterson.
Ellie's on behalf of the people now.
Good morning, Your Honor. Kerma Dadush on behalf of Mr. Patterson.
Good morning.
Good morning.
I've seen you walking around. You haven't said anything all morning.
Well, you'll hear me 4 more times, hopefully.
Oh, that's a threat. Go ahead.
Say your name for the record, please.
Glad to say. Thank you.
Your Honor, I have submitted a green sheet. We are going to adjourn for mitigation purposes, and whenever there's a chance to address bond, please.
All right. Probably, well, the 4th give you enough time to get something.
I would, if you could, the 11th, that's probably better. It's more time for our mitigation department.
So all she had to do was say no. September 11th.
Thank you, Your Honor.
2025, 9 a.m. But as to bond.
Your Honor, Mr. Patterson is charged with an Arno from 2022. He did fail to appear his last court date.
Well, 3 of them.
Yes.
Yeah, go ahead.
But since 2022, he has had no other cases. He hasn't picked up any charges. He's been working. He has 10 kids now, 7 of whom.
Excuse me?
Sorry?
What do you say?
I said he has 10 kids now, 7 of whom are in his care. What? You want me to continue or stop?
No, I'm stuck on 10, but go ahead.
Okay. He takes care of 7 of them financially. He's gotten himself a job. He works in landscaping and home improvement. He's been at his job for a year. He sincerely apologizes for not appearing in 2022. He's told me that it was a dumb mistake that he didn't. He was immature at the time. He's trying to run away from his problems, but since then he wants to get his life back on track. He's already done so by not picking up new charges and by having a stable job. And he wanted to say something himself as well.
Yeah, I just want to say, being sure I was running from my problems. I didn't want to go to jail at the time, but now I'm ready to face my problems and get my warrants out the way so I can raise my family and have a clean slate.
How did he come into custody?
Traffic stop?
At the room, police contact.
What happened?
At the room at Days in with my friend. She had the room for her foster care son. He had did something. So they had both rooms and they came and knocked on
Hold on a second. So you came into custody not because you walked in from 2022.
He did not.
And he's at the Days in.
No, it was trespassing because her son was in foster care, but she had the room. They were playing.
You at the Days in when you got picked up?
Yeah, well, they came to the room. Yeah,
they came to the room.
To the room for her son doing something. And that's
Police contact that is unrelated to him.
Unrelated to me. Yeah,
He sh-
I didn't catch no, charge.
And we did talk about him. He should have turned himself in since then,
Yeah, you were, yeah, it was a big skip, but okay.
but you know, if your honor releases him on his own personal recognizance, it will come every single time.
2028, if his pattern holds.
There will be no pattern.
No, that's all, so.
Ms. Zender would like to speak. Ms. Zender.
I would object to any modification bond. As the court has pointed out, he did fail to appear in 2022. He also has other holds are set for a 1482 case for an OWI that's up on September 12th. That's a $100 bond. Then a DV out of 14B that's up on September 15th with a $100 bond. In this case, there are 3 RNOs, and when officers went to arrest the defendant on his warrants that he had at the time, he was pulling away, not listening, was taken to the ground, had to be tased, and still continued to pull away. And then he also, when they had to get him to the car, he went dead weight and had to be carried. So I'd be objecting to any modification bond, as well as with his criminal history. He's got 2 cleans that he was convicted of, a PVSC that he convicted on, a BB second, an unlawful driving away, and an OWI. So given the fact that he failed to appear for 3 years and had to get picked up, and then the facts of this case, I would object to any modification of bond at this time.
Can I briefly respond, Your Honor?
Give it your best shot.
All of these charges and his past history is from 3 years ago. The 2 cases that he has are $100 cash bond that convert to PR once he's released on this case. So he did PR on those. But all these allegations are from 2022. His criminal history is past that. He, again, nothing since 2022. Those other cases, I believe those are also from 2022. So they're not new.
The only reason they're from 2022 is because he didn't turn himself in for failing to appear.
I did say nothing new from 2022, after 2022 since then.
Well, there's new things. He just hasn't
appeared
on those either.
Well,
2 other courts.
They're from 2022. He hasn't appeared on them, but no new charges.
Because he doesn't seem to want to go to court. I do have some concern that he's at the day's end, gets picked up at the day's end.
No, it wasn't that. But you guys just hear me out. Can you hear me?
Okay, sure.
I was saying up at the room with my friend. She got a foster son that they was paying for the room. They did something, whatever. That's how I ended up getting picked up. So I didn't turn myself in. Yeah, I understand that.
Yeah, that's the point.
Yeah.
One more chance, Your Honor.
Okay, I'll show up to court home for 5 minutes.
Motion for bond reduction is denied. Bond will continue.
Thank you, Your Honor.
Thank you.
Court calls case People versus Devin Julia Martinez. In Zoom. Oh, yep.
We're ready in this matter. Vaughn Brown, Deputy Chief Public Defender, appearing with and on behalf of Ms. Devin Julia Martinez. Ms. Martinez, could you state your name for the record?
Devin Julia.
Your Honor, today is a date and time scheduled for a competency review. We have received a report dated July 16th, 2025. Would submit that for the record. Has the court received that report?
I have the one dated July 16th. If that's the one that you're talking about.
Thank you, Your Honor. This matter was scheduled last minute. We do not have well, first of all, we don't have any further evidence to present to the court.
Any other evidence from the people?
I reviewed my internal file and I have not seen that competency report. I just Mr. Brown's handing a copy.
To determination that she's competent to stand trial. I believe you may not have it in your file because I think Judge Hamoud may have ordered competence. Right. That's 100%, but we received a copy.
Okay. Thank God the people have no further evidence.
All right. Based upon a review of that report, the court would find that the defendant is competent to stand trial. Specifically, the court would find that the defendant can understand the nature and objects of the proceedings against her and can rationally assist in her defense. Therefore, the defendant is deemed competent.
Thank you very much, Your Honor. We will prepare an order to that effect.
All right, and what would you like me to set the next proceeding for?
May we please have a probable cause conference date?
I'll set a probable cause conference for my next available date of August 28th, 2025, 9 a.m.
Thank you very much, Your Honor.
Sir, what is your name? The lawyer. Sorry, you? What's your name?
Lawyer?
Yeah,
I'm Attorney Brown.
Brown, Mr. Brown. May I call you at the public
Yes.
defender's office?
You certainly.
Sure, he's there all the
Please
time.
feel free.
Awesome, thank you.
All righty. Ask for Lauren Brown.
Ask Ronald Brown. Brown, no.
Thank you. Yeah.
Why would he do that?
Judge.
But
this is him. This has to be my state court. Doesn't mind.
It's not the worst though.
You're glad, you're lucky my staff likes you. Court calls the case, People versus Colin Spry. I'll call it up with your other one, Mr. Killer.
Assistant Public Defender Lamia Saab on behalf of Mr. Spry. Mr. Spry, can you please state your name for the record?
Colin Spry.
Thank you, sir.
Oh, I'm sorry. That's good.
Hey, you're requesting an adjournment. At my next date, she's in custody. My next date would be the 28th. Would that be enough time to get the mitigation and try to?
Yes, Your Honor.
One more week out.
That'll be perfectly.
28th will work. Okay.
Yes.
Probable cause conference will be August 28th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court does call the case of the People versus Christopher Atkins.
So this bearing on behalf of the people.
From Livingston. Oh, there, okay. Christopher Atkins?
Yes, Your Honor.
Okay.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Atkins.
You have a camera there, sir, or no?
Yes.
Oh, there he is. Okay, we got you. State your name.
Christopher Roy Atkins.
Thank you.
Your Honor, we're asking for an adjournment. I know Mr. Atkins has been in contact with Mr. Bowling from our office. We are tracking his case in Livingston. He may be sentenced into a treatment court that would kind of help resolve the case here. So my understanding, Mr. Atkins, I looked yesterday, it looks like that was adjourned to the 22nd of August. Is that correct?
Yes, and I don't qualify for the mental health treatment court. I think they were trying to get drug court, which is similar. But yes, 22nd is my next court date here. I also have 12th here, September. So I have the 22nd, 12th of September. I'm not sure. I haven't talked to my lawyer what we're doing. So I qualify for mental health that I was.
Okay. Mr. Atkins, could you, we're going to adjourn today. Can you give our office a call and so that we can talk about what the status of your other case is?
Yes.
Did he say that other one was adjourned to September 22nd? Or
I
August
believe he has I don't want to say a new, but it looks like there was a case that was bound over, and that's in September. I did not get the date on that. What's your September court date?
I have the September court date is 12th.
September 12th. So if we could have a date after
the 12th.
The 12th.
Sure. All right. Probable cause conference then, in this case, we'll probably hit right in the middle of those, will be September 18th.
Okay.
2025, 9 a.m. Bond will continue.
Thank you.
All right. Thank you, Mr. Atkins. Call your attorney's office, please.
Thank you, Your Honor.
All right. Court calls the case, People versus Jonathan Faith.
Joseph and Gilman, people.
Good morning, Judge. Lawrence H. Margolis with and on behalf of Mr. Faith, who is to my right. Mr. Faith, please introduce yourself to the court.
Morning, Jonathan Faith.
We've executed a waiver in this matter, Judge.
Why do I? What?
Say it again, sir.
This is his file. We should wait that he filed today. I understand.
That's the term, right? Oh, he's only, I got you.
Yeah.
I got you. All right, sir, you're waiving your right to a preliminary examination?
Yes, sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes, I do.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution?
Yes, I do.
People also waive the right.
We do, Your Honor. Thank you.
Preliminary examination having been waived, defendants bound over to circuit court on counts 1 and 2 with 3 and 4 following.
Judge,
Your turn, Margolis.
Thank you, Judge. We're in receipt of the felony information. We'd ask Your Honor to enter a plea of not guilty and waive.
Defendant having waived formal reading, pleading not guilty as to all 4 counts, court will enter that plea. Pretrial will be set for
October 15th at 1:30 with Judge Conlon.
October 15th, 2025, 1:30 before Judge Conlon.
Thank you, Judge.
Bond will continue. Thank you.
Have a good day.
You do the same. Court does call the case, People versus Jamie Foxx.
Andrew Childers, appearing on behalf of the people.
Good morning, Your Honor. Ellis Friedman on behalf of Jamie Foxx.
Morning, Judge. Assistant Public Defender, also on behalf of Ms. Fox.
Good morning.
Good morning. Your name?
Jamie Foxx.
Thank you.
Thank you, Judge. I haven't had the chance to speak to my client and to her other counsel. On my file, we are requesting this matter be set for preliminary examination.
That's, which one is yours versus?
We believe we have the discovery, Your Honor.
0223.
You want to exam also?
We've been trying to keep the case together.
I think we're ready now.
Okay. All discovery is complete then.
That's our understanding.
People have their witnesses available to second.
Your Honor, I don't think I'll be able to have the private guest up by the second.
Okay. Ninth?
Ninth is good.
Ninth is good. Will that work for you, Mr. Christian? And hearing no objection from the people. Bless you, whoever that was. Preliminary examination will be set in person September 9th, 2025, 9 a.m. before Judge Valvo in both matters. Bond in these cases will continue.
Thank you, Judge.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, ma'am. I don't know why. Who knows? Court calls the case, People versus Delo Thomas.
Alexander, on behalf of the people, Your Honor.
Well.
Mr. Tommy?
Yes.
Did you want the adjournment?
Yeah, just. Okay.
Thank you, Your Honor. Stephanie Cannon, on behalf of Mr. Thomas. Mr. Thomas, could you please state your name for the record?
Delo Thomas.
And we
sir.
are so happy to be here today, Your Honor, and we're going to ask for a 2-week adjournment of this matter to see if some discovery can be obtained.
All right, I have a little longer than 2 weeks, or I have 10 days.
Your Honor, if we could do the little longer than 2 weeks, I was informed there might be exploratory evidence on the defendant's phone, and that maybe officers taking pictures of it, so that might take to see if they did or what that is. Your Honor,
Okay. Then.
Your Honor, I do
given
believe
that I can do the 4th or the 11th, which if we have it by then. But
4th? Your Honor, we would ask for the 4th.
We can try something.
They took probable cause conference will be adjourned September 4th, 2025, 9 a.m. Bond will.
Somebody. Let me see if I can find them.
Thank you. Court does call the case People versus Heather Booth.
Joseph and Gomez, people, Your Honor.
Akmed Ajabori on behalf of Ms. Booth.
Ms. Rushing? She's on the other one.
Sorry, Judge, I was on the record in another matter. I apologize.
Not a problem. I called the Booth matter.
Sydney Rushing appearing on behalf of Ms. Booth.
Your Honor, Ms. Booth was going to show up in person. She is actually on her way to Richmond, Michigan to get herself into Sacred Heart. When she was released last, she was supposed to get released into treatment immediately. There were no beds for her, but now there are. I would ask that Your Honor adjourn this case.
You come up with the most incredible stories. Some of them being true, some of them.
Well, actually, I was
You don't tell me
texting with her
you're not
right
going
now.
to just show me a picture of anybody on a bus.
No buses.
Going anywhere.
No buses. I was asking her to send me proof of her getting into Sacred Heart. She just sent me something. She only sent me her tether thing right now.
Her what?
Not a proof of tether. She didn't send me proof of her getting into Sacred Heart yet. She said it was a telephone call with CMH and is working.
So she's admitted into Sacred Heart. She's on her way there, you think?
Yes, I think.
Your Honor, that was my understanding as well.
I have two people telling you that.
What'd you say?
No, you have two people telling you that. So is it more?
I have two
believable?
people that talk
Rushing
to the
is-
same person telling me that. I don't know that that really bumps that up. Okay, here's what I'll do. I will issue bench warrants for the defendant's failure to appear in these matters. I, however, will not enter those bench warrants until the 19th day, till the 23rd. Well, 22nd is Friday.
Okay.
So if you get that information to us, I won't issue.
Thank you so much, Your Honor.
All right. All right, thank you. What? 10,000 cash sharing. Court calls the case People versus Owen Thurman.
People, Your Honor.
And Alex Warren Green on behalf of Mr. Thurman. Your name, Mr. Thurman? Owen Thurman. Your Honor, we are asking to set this matter for preliminary examination.
Discovery is complete.
Believe so, Your Honor.
People have their witnesses available the second.
We'll do our best, Your Honor.
Preliminary examination in person will be set September 2nd, 2025, 9 a.m. That is before Judge Perry. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls the case of the People versus Christopher Taylor.
Joseph and Gomez, people.
On behalf of Mr. Taylor, who's approaching and stands to my right. Mr. Taylor, please introduce yourself for the court.
Christopher Taylor. Thank you.
Thank you, Your Honor. Your Honor, I was fairly recently appointed on this case. We are still working on discovery on this matter, so we're asking for a brief adjournment.
Without objection, September 4th, 2025, 9 a.m. Bond continue.
Thank you, Judge. Here, take this.
Court calls the case People versus Cody Wines.
Joseph and Gomez, people, Your Honor.
Assistant Public Defender Sandra White on behalf of Cody Wines. Mr. Wines, can you state your name for the record?
Cody Michael Wines.
Your Honor, I'm asking for an adjournment of this matter. I believe this is the first hearing for further negotiations and to review video with Mr. Wines.
Probable cause conference, August 28th, 2025, 9 a.m.
Thank you.
Bond continued. Thank you. Court calls case People versus Maz Sharif.
Morning, Your Honor. Mustafa Houili on behalf of Mr. Sharif, who's to my left. Sir, please state your name for the record.
Maz Sharif. All right.
Your Honor, today's a day for PCC. There are two cases in this matter. There is a felony larceny and a unlawful driving away of a motor vehicle. Your Honor, he was arraigned last week. At this point in time, we've only received paper discovery on the larceny. We haven't received any discovery at all on the unlawful driving away. So I'll leave it to the discretion of the court judge if if you'd like to do an adjourned PCC for us to get up to date with discovery, or if you want to set it out for exam a few weeks out to give us enough time to review discovery and determine what we want to do with the exam.
I don't set exam until discovery is complete. You're telling me discovery is not complete. How much time do you need to get it done?
Judge, we just need the discovery on both matters. They're still outstanding, maybe a couple weeks.
That objection, probable cause conferences will be adjourned September 4th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor. Have a good day.
Thank you. Court calls case People versus Douglas Wren.
Lord Yaki, Assistant Public Defender, with and on behalf of Mr. Wren, who's approaching. Mr. Wren, could you state your name for the court?
Douglas Wren.
Your Honor, I have been in communication with the people on this matter. There's no offer available, and so I do believe discovery is complete. We would ask that this be set for them.
People have their witnesses available September 2nd. Preliminary examination in person September 2nd, 2025, 9 a.m. That is before Judge Fleischer. Bond will continue.
Thank you, Your Honor.
Court calls case for the People versus Mary Collins. Collins, I think it's.
Robert, on behalf of Mary Collins, who's approaching the podium. Ms. Collins, you can okay, please state your name for the record.
My name's Mary Collins.
Thank you.
And one just says date and time set for probable cause conference. We are working on mitigation, so we ask for a brief adjournment at this time.
That objection, probable cause conference will be adjourned September 4th, 2025, 9 a.m. Bond continued.
Thank you, Judge.
Court calls case People versus Zaria Brand.
Hey, Alexander, on behalf of the people, Your Honor.
And Lord Yaki, Assistant Public Defender, with on behalf of Ms. Brand. Ms. Brand, could you state your name for the court?
Zaria Brand.
All right, I have before me a plea sheet that indicates that defendant would be pleading to count 3, domestic violence, a 93-day offense. Upon a successful plea, counts 1, 2, and 4 would be dismissed. Defendant is agreeing to pay full restitution, and there's a sentence agreement or recommendation to sentence under 7694A. That's the court's full understanding of it.
And that's correct.
Yes, Your Honor.
All right. May I have her sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Zaria Brand.
All right, ma'am, it is this court's understanding that you're going to plead guilty to the charge of domestic violence. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand that?
Yes.
All right. You understand also, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Yes.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
I plead guilty.
You understand that by pleading guilty, you'll not have a trial of any kind?
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5 on that form. You'll see a copy there. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Anybody promise you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense?
Yes.
Seriously? Of course, hold on. Here we go. On the date of May 19th, 2025, at the location of 755 Campbell Avenue, apartment 12, Ypsilanti Township, Washtenaw County, State of Michigan, what do you do on that date involving a Marquise Maddox that makes you think that you're guilty?
I threw a nail gun.
You threw a what?
A nail gun.
You threw a nail gun?
Yes.
At him?
In the direction of him, yes.
Okay.
It never made contact.
Okay, good. But you were intending to place him in some apprehension of that contact happened?
Yes.
Yes. All right. And who is this individual to you?
My son's father.
Ma'am, I would have to advise you that if I do accept your plea, if you commit misconduct between the time of my acceptance of the plea and the time of your sentencing, any sentence evaluation, in this case, the court would no longer be bound by, and you would not be able to set aside your plea. You understand that?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
All right. And have I complied with the court rule? Would it be proper to accept this defendant's?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 3. Counts 1, 2, and 4 are dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
September 22nd at 10 a.m. Judge Washington.
September 22nd, 2025, 10 a.m. That is before Judge Washington. Bond with its conditions will.
Your Honor, I apologize. May I address a bond condition?
She's out.
I understand. She does have a tracking tether.
Changed?
No, Your Honor.
Okay. Go ahead.
She does have a tracking tether. I believe she's had one since May. Is that right? Since she was arraigned on May 20th, which is the date after the incident in this case.
After she threw the nail gun?
Correct, Your Honor.
Okay, go ahead.
There's, to my knowledge, been no bond violations. Ms. Brand works. She's a working mother and she's in school. So she's starting her semester in just a few weeks at WCCC studying psychology. And so she has a very, she's very goal driven and focused and wants to become.
Is she at Wayne County or Washington?
Washtenaw. Did I?
Yeah, you include one too many C's for Washington. You've done that like 3 times already. It's okay.
Thank you for correcting me. I apologize. Yeah. Okay.
You're welcome.
WCC.
Yes.
Okay. And she, so she would ask, given her lack of bond violations and her close supervision, now that she's pled guilty, she understands that any misstep, any violation will not only compromise her liberty in terms of going to jail, but it will also compromise her record and her future career in terms of losing 4A. So I would ask if the court would consider removing the tether.
Response.
Your Honor, at this point, I would object. I think it's something that could be addressed at sentencing. Given the facts of this case, I would ask that the tether remain at least until sentencing.
All right. What I'm going to do is I'm going to let Judge Washington's probation department make a determination after they at least interviewed her before that tether is removed. So at this point, I'm going to deny your request for a bond.
Understood, Your Honor. Thank you.
Thank you. Court does call the case People versus Dominique Brewer.
And sure this is on behalf of the people.
Ahmed Adush with and on behalf of Mr. Brewer. Please state your name for the record.
Dominique Brewer. Thank you.
Your Honor, we're just asking for a short adjournment, please. About 3 weeks, if Your Honor is willing to do so.
Probable cause conference, September 4th, 2025, 9 a.m. Bond.
Thank you, Your Honor.
Thank you, Your Honor. Thank you, sir. Court calls case, People versus Andre Brooks.
And that was on behalf of people. Assistant Public Defender Tesa Michael Tesarian on behalf of Andre Brooks. Please state your name.
Andre Brooks.
We'd like to set a preliminary exam.
Discovery is complete.
I believe so, Your Honor.
You will have their witnesses available the second.
We'll do our best, Your Honor.
Preliminary examination in person, September 2nd, 2025, 9 a.m. That is before Judge Perry. Bond will continue.
Thank you, Your Honor.
Thank you. Court does call the cases of the People versus Eric Buckner.
Ready then.
Joseph and Nolan.
On Brown, Deputy Chief Public Defender appearing with and on behalf of Buckner who approaches the podium. Mr. Buckner, state your name for the record.
Eric Buckner.
Buckner, at this time, we're respectfully requesting an adjournment of a little over 2 weeks. Mr. Buckner has medical appointments. He also would like to be able to decide.
Sorry. He has medical appointments.
Yes. Have.
Will the fourth work?
Yes, fourth, please. Do you need to see the
Probable cause. What is it?
Just proof of his medical. He's got 3. That's okay. All right, thank you. Another word.
Probable cause conference, September 4th, 2025, 9 a.m. Bond will continue.
Your Honor, may we address just one aspect of the bond? He is out, but he's on home confinement. He has a lot of these medical appointments, and they're going to vary, they're going to change. Just asking that the bond be changed to maybe a GPS so that he can go to work as well. He does need to be able to work to be able to pay his rent. He's got bills that are coming up. The home confinement prevents him from doing that. But mostly it's the medical appointments. He has 3 verified appointments that are coming up very soon. He's going to have more after that. So we're not asking that he just not have any kind of supervision, just a different kind.
I would indicate, I guess, I don't need a response necessarily from the people given that request, but what I would do is I'm going to leave the home confinement in place, making an exception for a verified medical appointment. We just need to turn that into any corrections.
Okay, can he also do employment too? Because the home confinement prevents him from even working. He's got to be
a response regarding the employment. Is that, I mean, for employment to work, to actually work, or
yes,
for interviews?
No, I actually have a job, Your Honor.
He does have a job.
I have a job.
Your Honor, but the definitive of verification that employment.
Okay, sorry, he's got something here.
All right, so what I would do, Mr. Brown, if you prepare an order, get it over to the prosecutor's office, and it had to be today. For my signature, allowing his attendance at the medical appointments as well as employment.
Okay.
I will sign off on that. That can get over to community corrections.
Thank you very much, Your Honor.
Thank you. And September 4th, and Bond will continue with the changes. Court calls the case People versus Maurice Virgin.
Andrew Children appearing on behalf of the people.
What's called? Virgin. Our prep row. Scooby.
I apologize, Your Honor. Lori Yaki, Assistant Public Defender with and on behalf of Mr. Virgin. Could you state your name for the court?
I'm Maurice Virgin, Your Honor.
Your Honor, may we approach on this matter?
Is there really a need?
There's a lot of updates that I've been talking with Mr. Virgins about, and
is that to the use of recreational marijuana, which he's not supposed to do, or to the cocaine? Which is the update?
Well, it concerns both, Your Honor. It concerns all of the steps that he's taking, and specifically the documentation that he went to Home Division yesterday And we are waiting documentation, and
Documentation for what?
that he did his intake at Home Division yesterday.
As well as CMH.
As well as CMH. And he came in with a written plan in his notebook. And I can honestly say I did not even tell him to do this, but he came in with a written plan about how he's going to stay clean.
If I test him today, is he going to test clean?
Yes, sir. But I won't in 2 days. Your Honor,
What?
Your Honor, I'm not lying to you. Judge Simpson, I've done everything that I could possibly do to make sure that I can continue to stay in society. I have a job. I start tomorrow at Full House Restaurant on Equals. I went to CMH and did my intake. I also went to Home Division and spoke with Mr. Marcus, who is a recovery coach on E-Course. All these places are within a half a mile from each other, from the hotel living in now. So I'm in position to lose my room, my residence, as well as my relationship with my fiance, who's clean and clinging on by her fingernail, because I'm trying my best to do my best to change my lifestyle, sir.
What are we doing with this case?
So I do have a green sheet, Your Honor. This is a case that is from, I believe, 2022. It's a possession. And I would ask to adjourn it because I'm hoping it comes to some sort of resolution. The bottom line is Mr. Burgess knows that he needs treatment. And I've had a lot of conversations with his fiance and him, and I really do think they are very active in making sure that he gets help, stays out of trouble. He just got this job. He has the sweatshirt that he's wearing. And he's eager to prove himself. And I think he's very genuine when he says, I mean, he asked me to ask this court to let him prove himself and to show with his actions that he is following up, that he's good to his word. I did call Home Divisions this morning and verified Mr. Marcus. I'm just waiting for his email response to come through, that he did actually go to the meeting yesterday. I did verify with his fiance, who is with him, that he did that, and that he is clearly not using. He came to court knowing that he had this bond violation, knowing what he risked in terms of his liberty, but he wanted to do the right thing, and he wanted to stand before this court to ask for the opportunity to show that he can be clean, he can be sober, he can be in the community, and he will do the right thing. He's very eager to prove himself. He has no other cases, not on probation or parole, and he has this new plan.
Recovery coach, a new plan. A new
and he's
residence.
going to Little House meetings multiple times per week.
I start work tomorrow, y'all. I just need an opportunity to prove to you that I can do the right thing. I know I've made some mistakes, some horrible decisions. I'm 62 years old. I'm old enough to know right from wrong. And I apologize for my shortcomings, but I'm trying to do the right thing. I can't prove it to you from there.
I have 4 positive tests. He's been using cocaine. It almost less than a week ago, I have a positive test regarding that.
I understand.
He doesn't have a valid medical marijuana card. He's also been using marijuana or THC at least in the system. You're telling me now, the day before he's to come to court, he's now in treatment.
I started.
And somehow or another, I'm just supposed to say all of that's okay.
Well, Your Honor, he knows it's not okay. I think what makes him really different is he is coming, he is testing, and he is doing his best. It is obviously a struggle for him to battle his addiction, but he is not getting in trouble. He's going to meetings. He's doing the best that he can. And I think he's doing what, especially on his own initiative. I mean, I was surprised yesterday because he doesn't have his own cell phone. He shares with his fiance. And before I even talked with him, he came up with this plan himself. And I think that goes to show that he is taking the initiative to do this himself. And he is using this added accountability of testing. He knows that he's going to lose his liberty if he tests dirty one more time. I mean, he knows that. And he knew that coming into court today. And he still came in anyways because he wanted to prove to the court that he is willing to take that chance. And he said, the court certainly will revoke my bond if I test positive again, but I'm not going to because I'm serious and I'm serious about recovery. And so I would ask this court for one more week, one more opportunity for Mr. Bergens to prove himself.
I can do it, Your Honor. I promise. I'll be locked up if I go. I can't do anything from jail. I have a job now, and I want to prove to myself as well as this court.
Anyone can do jail.
Sir?
Nothing.
I'm sorry, Your Honor.
I'll adjourn this out to the 28th, 2025 at 9 a.m. I don't need a response from the people. Defendant's bond is revoked. If you send me the proof that he's enrolled, I'll reconsider the revocation of his bond. But until such time, his bond's revoked, defendant's remanded. Sorry, something. Dr. Magnet. Court calls the case, People versus David Davis.
Stephanie Cameron, on behalf of Mr. Davis.
How come Ms. Saab has your sheet? What?
She's way more efficient than I am, Your Honor.
What?
She's way more efficient than I am.
Oh, I know. I was so happy to see her today.
I know. Your Honor, in this particular matter, we are simply, I'm sorry. He threw me. We are simply requesting a two-week adjournment. Because he was sitting here just as patient, doing this thing that he does like this, staring at me.
Ooh. Okay, so first of all, do not flatter yourself. He wasn't staring at you.
He was.
All right, now.
With expectation that I hand over the green sheet, Your Honor.
Oh, okay, whatever.
So, Your Honor, we're simply asking for a two-week adjournment in this matter for possible plea negotiations.
Sir, your name?
David Davis.
Thank you. How long did you need?
We're just asking for 2 weeks. Or I understand the court is not available in 2 weeks potentially, so at the court's earliest convenience.
Stop it. You
see how we do? See
September 4th, 2025, 9 a.m. Bond continued.
Thank you so much, Your Honor.
Thank you. Court calls the case, People versus, is it Eric Davis?
Alexander on behalf of the people, Your Honor.
And Alex Warren Green on behalf of Mr. Davis. State your name.
Eric Davis. Eric Davis. Thank you.
Your Honor, I have a green sheet for the court. We are requesting an adjournment to, so I can review discovery with my client.
Probable cause conference, September 4th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls the case of the People versus Samuel Freeman.
Assistant Public Defender Chelsea Virgils on behalf of Samuel Freeman. Your Honor, I received communication from Mr. Freeman this morning that he's a dialysis patient and he had a dialysis appointment and ran a little late. Would you consider passing the case to allow him a few more minutes to appear? I believe he's on his way here.
Said that so nicely. She did? Denied. No, I'm kidding. All right. I'll pass it. Let's see if we can get here. Between you and Kilowald. Court calls the case, People versus Lamia Gresham.
Alexander on behalf of the people, Your Honor.
Chelsea Virgils with on behalf of Maya Gresham.
Is Lamia. See, no.
I'm not positive.
I always put I put it in the wrong place. It's okay.
Your Honor, we're asking
Not
for
like everybody else being critical. But it's okay. I'm sorry. Go ahead.
Your Honor, we're asking for a preliminary exam in this case.
Discovery is complete.
To the best of my knowledge, Your Honor.
People have their witnesses available on the second.
We'll do our best, Your Honor.
All right. Preliminary examination in person, September 2nd, 2025, 9 a.m. That is before Judge Fleischer. Bond will continue. Thank you, ma'am.
Thank you. Thank you.
Court calls the case of the people versus Jennifer Gray.
Joseph and Yolanda people.
Assistant Public Defender Ben Dunawith on behalf of Ms. Gray. And could we approach the bench?
Your name, ma'am? No, they can come on.
Jennifer Gray.
Thank you.
Your Honor, I had a new offer. Got a plea rejection here. He'll sign it. If not, I'll send it on.
Okay.
And I'll put the offer
Did everyone get a copy of this latest?
Sign this right here, Carolyn, this is rejecting the offer. Right there.
Is this on the first page?
Yep, go ahead.
It's mandatory, right?
Not mandatory.
If you want to go to trial and not accept a plea agreement, then listen to your attorney and do what he's telling you to do.
Okay, so basically it's completely off the table right now, the plea?
Yeah.
Right there, and there.
What's all this?
Defamation, man. They've been gaslighting me for 5 weeks straight. Been doing my best to get to the population going and try to stay out of trouble. They all up on the microphone.
All right, this is, stop talking. This is cause numbers 24 DCCR 1500, 24 DCCR 1614, 1615, 25 DCCR 0436, and you're Traylon Hill. And Mr. Hill's charged, let me go through this, in cause number, the first one, 1500, with obstruction or retaliation. Do not do that again.
My apologies.
Who's in here for him?
My grandmother.
All right, ma'am, can you move over to that back corner so that he cannot see you and be distracted? Thank you for being here. Mr. Hill, you just don't know how to behave, do you?
I apologize.
Saying you're sorry doesn't matter. This is nonsense. Since we were here last time, I don't even know how many more pages of the nonsense that you've been doing in our jail.
It's gaslighting. It's solicitation.
Okay.
And I've been trying my best to stay out the way. I've been getting bullied over the microphone. I have inmates there encouraging the inmates to harass me, calling me punk, alpha, profit, plenty of things. Gangster player, mad.
Yeah.
Mortar. Man, I'm just trying my best to stay out the way.
Okay.
I got a job. I got a home. An actual home. I don't stay in apartments or anything like that. My mama actually owns rent houses. And you know what I'm saying? I'm actually trying to take care of the family business. My dad's 76 years old.
Yeah.
My best to stay out the way.
Well, it doesn't look like you are.
Yeah, it's tough in that facility. It's a war zone.
So one of the time you're running back and forth, playing like a little kid in the day room.
I work out.
Who made you do that?
I'm a boxer. I work out.
Are you allowed to do that in the jail?
In the rec room, yes.
Okay, so are you allowed to do it in the other room?
I have a one-man cell in the facility.
Are you allowed to do that
Yes, ma'am.
You
I'm
are?
not running freely throughout the facility or anything like that, but I do work out a lot every day.
So who made you dash the floor with water?
Everyone in that facility has a water
Who
bottle.
made you dash the floor with water?
I'm not the only one. That was
Listen
me.
to my question.
No one did.
No, but you did it on your own,
Yeah,
right?
it wasn't
Nobody's going to
against-
stop talking when I'm talking. I'm going to ask you some yes or no questions.
Okay.
So nobody's making you do those things, right? Nobody bullied you into dashing water, right? Yes or no?
Yes, ma'am.
Okay, hold on a second. What about why do you continue to make comments to the female officers out there? Why do you think that's okay after you've been told not to do that?
Sitting in the field all day long, man. When I see them women, I get deferred. I'm a little bored. I admit that.
Because you're a lover boy.
Yes, ma'am.
So you understand that part of all of this trouble and you not being able to get your cases worked out is because you can't follow that rule.
Yeah, I hate that.
Did somebody bully you into being that way to those officers?
In a manner, you know what I'm saying? When I'm dealing with these stressful inmates, you know what I'm saying? I love to be around mom.
Okay.
My mama boy.
Judge, based on his Sunday night activity, I'm pretty sure there'll be a new case coming.
Yeah.
I've got to call into the investigator for the sheriff's department to find out when they'll bring that over. But I would ask that we go ahead and set these in for trial.
And we've already talked before about the fact that everything that's happening, a jury is going to know about all that. You understand that? Okay. And do you think that's going to help you or hurt you when a jury hears how you're behaving in the jail?
When it comes down to video footage and how I explain it, I think my efforts would be pretty good.
You think so?
Yes, ma'am.
You think and cause number 241500, you're charged with obstruction or retaliation. Is that a third
That is a third
degree felony, which means if you're found guilty, the range of punishment is between 2 years and up to 10 years. Do you understand? And cause number 24 DCCR 1614, you're charged with aggravated assault with a deadly weapon. And second degree felony offense, which means the punishment range is between 2 years and up to 20 years in prison if you're found guilty. Do you understand that?
Yes, ma'am.
And cause number 24 DCCR 1615, you're charged with aggravated robbery, which is a first degree felony, which means if you're found guilty, the range of punishment is a minimum 5 years up to life in prison. Do you understand?
Okay.
And then in 250436, you're charged with burglary of a habitation, which is a second degree felony. The punishment range in that is between 2 years and up to 20 years if you're found guilty. Do you understand?
Correct.
I have here on the computer a plea bargain rejection that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 10-year term in prison on a lesser offense of robbery.
Of robbery and dismissal of the other charges.
You have every right to reject that.
It was an excellent deal, but
That's fine. I just want you to know that after today, I will accept no plea agreements. A jury is going to decide because I don't know that I even agree with this. So today's the day. If you want to take it, fine. If not, you're going to trial. A jury will decide if you're guilty or not. And then if you are found guilty, that jury will determine what your punishment is. And is that what you want to do?
are all these charges going to be on one trial?
They don't necessarily have to be because you've got three different dates.
Your Honor, the robbery and aggravated assault are the same offense day. I'd expect to try them together.
Okay, so what can happen is you will, it sounds like the aggravated assault and the aggravated robbery will be tried together. It's important that you understand also, if you're found guilty on those, then the state can also try you later on one or both of the other cases. If you're found guilty on those, because the offense dates are different dates, there is the possibility that any sentence that a jury gives you could be stacked or run consecutively. Do you understand?
Right.
Okay. All right, we'll get it set for trial. Go back with the bailiff. Good luck, Mr. Burbank.
Thank you, Your Honor.
I don't know that I've ever been so mad at a defendant. Can't help it. Kevin Ross, Mr. Burbank.
I mean, we started.
Yeah. It's gonna keep on getting worse because the jury's gonna. And there's no paperwork on Mr. Ross, right?
I do have a bond request.
Oh.
You said turn around? No, I don't want you to turn around.
He said, how are you doing?
Oh, yeah. How you doing?
Good morning, you're Kevin Ross?
Yes, ma'am.
And so Mr. Ross has two motion to revoke probations, cause number 24, DCCR 1198, on probation for the offense of a deadly weapon in a penal institution, and in 24, 1199, evading arrest or detention with the use of a vehicle. Mr. Burbank has filed motions asking that I set bonds in these cases. Give me just a second to get this pulled up.
Judge, if I may, just.
Yeah, go ahead.
Inform the court, we have discussed this at length, Mr. Burbank and myself. I have made several requests to DPS via my investigators to bring the new evading. Typically, we could proceed on a motion with just a probable cause affidavit. The alleged egregiousness of this evading lends to an absolute need for the video, which is what Mr. Burbank wants. Considering DPS has not brought that, I feel like in fairness, I cannot oppose a bond for this defendant because I think that the video itself will be dispositive of either he was driving or his brother was driving, is my understanding. I've made requests of the trooper and we just have not brought it in. So June 13th.
And if I may add, Judge, I will represent to the court, I do have an affidavit from another individual, but I need the video because we could really shortchange, get right to the point.
Who's the trooper?
And I'll try to reach out again.
I'll reach out this afternoon after docket. So I'll figure, it looks like there are other allegations.
I'm sorry, Judge.
And so,
Garcia, Jordan Garcia.
I'm sorry.
Jordan Garcia, I had Sanchez Simpson.
In addition, Your Honor, I just,
yeah.
In my motion, I also add, if you were to consider a bond, some other requirements that I believe would be necessary.
And I've spoken with his probation officer and she understands the situation.
So we've got allegations of the evading with a vehicle and just an evading on June 13th. And then possession of marijuana from June 13th as well. And then drug patch, tested positive for cocaine. Out past curfew, June 13th at 1:39 a.m. Okay.
I have the PC on that today, Judge, if that would help.
I think I might have it right here. Let me take a look at that as well. Here's what I'm going to do today. I'm going to hold the motion to set a bond. We're going to, I'll contact DPS as soon as docket is done to see what it takes to get that video. If we can get it quickly, then everybody can look at that and see where we are. If for some reason we cannot, then I will reevaluate and set bonds at some amount based on the nature of the allegations and all of that. So, but
Mr. Bates reach out as well, Judge.
Okay.
This morning, you're on the bench.
Okay. If you'll let them.
When they know the court is.
If Detective Bates will let them know that he's gonna call them or I'm gonna call them, so maybe they can get that very quickly. And we'll go from there. All right, go back with the bailiff. At the most, we'll reset it for a couple of weeks. But if we get that, then we'll figure it out as soon as we have an answer today. I'll get with both of you. Okay, go back with the bailiff. And then you have Carrington Scott.
I can announce if you don't want to announce.
No, we need to get them out, please. Oh, okay. Have we seen or heard from you? This is Mr. Smith's case on Carrington Scott. Good morning. Are you Carrington Scott?
Yes, ma'am.
And this is 25 DCCR 0538. Mr. Scott's charged with robbery. Mr. Burbank?
Your Honor, I have reached out to Mr. Smith. I understand what's going on. There is a video that is missing, and he was attempting to try to get it. The court can do two things. It would probably be dispositive of this case if it received, it's a convenience store robbery, and some of the cameras were missing.
Okay.
The tape. If you want to reset it for a couple of weeks, I don't know when Mr. Smith will be back.
I'm sure Ms. Malfino or Mr. Nichols can
We
step
can
in.
handle it, Judge, and I just want to let the court know, Mr. Smith has documented that he did reach out to the detective on August 12th. I'll just be happy to follow up.
Okay, thank you, Ms. Malfino. So we'll just,
Convenience store video, some of it was already erased, so I agree it would be dispositive.
Okay.
Be dispositive of it. I mean, he's rejected the 15 years from Mr. Rojas, Judge.
all right, we'll just do maybe about 3 weeks. That'll give Mr. Smith, when he gets back, or Ms. Malfino, sounds like she'll step in and try to take care of getting whatever information they can so that we'll, if they have it, you can see it. If they don't have it, then we'll figure it out from there as well. All right. Thank you, Ms. Malfino.
I think that's all I have.
It is. Thank you, Mr. Burbank. Mr. Lewis, you have Derek Ardwan. It's a sentencing. Good morning.
Right.
Good morning. Are you Derek Ardwan? And Mr. Ardwan was previously in court in cause number 25 DCCR 0350, entered a plea of guilty to the second-degree felony offense of sexual assault. The agreement was for a cap of 6 years in the institutional division of the Texas Department of Corrections. I have received the pre-sentence report. Has everyone had an opportunity to review that?
We have, Judge.
Any additions or corrections?
No, from defense, other than something I'll clear up on argument.
Okay. Go ahead.
Well, Judge, when you review the PSI, it's several times Mr. Ardwan does take responsibility for what happened, for his actions. I know there was some talk from the PSI writer that it seems like he was minimizing or still deflecting some of his responsibility in what happened. I did speak to Mr. Ardwan about that. He said that toward the end of their interview, he understood more what the PSI was saying, because there was 2 people from probation there at the time.
Yes, sir.
And so as the second person started to intervene, he understood, and so he totally takes responsibility for what happens. He understands the situation. He shouldn't have been in, him or the complainant, during that situation. He was going through a situation with his girlfriend. It wasn't his wife. It's not his actual stepdaughter. His girlfriend, and started getting more attention from the stepdaughter than he should have, and he went along with it. Shouldn't have, but he did. It wasn't a situation where someone was underage or anything like that. She was definitely at the same age. Being in a relationship with him, they had started hanging out a lot more, almost in a dating scenario, if you will. And then it escalated to the point where they worked together that evening. Nothing of force, anything was happening. To my client understanding at the time, he thought everything was consensual that was going on. It wasn't until later, until this investigation, that he realized her stance or argument of her being intoxicated to the point in which she couldn't give consent, legal consent or anything during the activity. I would like to point out with him, when you look at his criminal history, he has not had any type of criminal history since 2001. So since he was in trouble that one time or that last time there, he has done everything he can to try to keep his life on track and not revert back to any of the old activities he had when he was younger. My understanding is, he does have a lot of family support. I've been in touch with several members of his family that have reached out to me. My understanding is that the mother of the complainant is still very supportive of it. And to the point where, even though he moved out and was away from her and everything like that, she still wanted to pursue their relationship and work on their issues. He is asking that the court consider community supervision in the situation. I think it definitely could be appropriate here in a situation where he's a registered sex offender at this point, so he will be able to get any of the attention or that he needs through any sex offender classes or through their registration, as well as I think that there's several vehicles available through probation that could help with any other additional issues that he does have. So at this point, Judge, we are asking that the court consider deferred adjudication in the situation with Mr. Hardwell.
Thank you. Ms. Malvino?
Judge, although the PSI reflects that they were unable to contact the complainant, the notes in the case reflect that our office has, and she seemed cooperative and wanting to go forward with the prosecution based upon that, based upon the nature of the offense, the circumstances that even Mr. Lewis himself has described with respect to, she may be considered a legal adult, that the difference in their age is quite substantial. Obviously, he took advantage of the fact that she was making bad choices with respect to drug and alcohol use and got herself in this position. So on her behalf, Judge, the state would argue for the 6 years under the cap, but defer to the court's discretion, of course.
Thank you.
And if I just may confirm, in case the question arises, he has already completed the sex offender registration paperwork.
Oh, yes.
Yeah,
Yes,
I think we did that at the plea. Mhm.
Just check.
Thank you. So I guess my thought is on this, I don't disagree with Ms. Malfino that prison time isn't necessarily warranted. It sounds like you got yourself in a predicament that you're way old enough and grown up to know better. She wasn't a minor. There was a lot of things that looked like they were consensual up until a certain point where y'all probably, it sounds like we're both so intoxicated, you clearly didn't know what was going on. 6 years, you're out in a few years. There's no treatment. There's none of that I think would be helpful. And so I think, to me, the better and maybe even more difficult thing for you is probation, because this type of probation is not going to be easy. So what I'm going to do is find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to defer all proceedings and place you on probation for 10 years. There's two things that are, well, let me finish and then I'll go through some other stuff. I'm going to order a $1,000 fine. I'm going to order that you follow all of the rules and conditions of probation, and that includes entering and successfully completing a licensed sex offender program. To successfully complete the program, you also have to admit what you did. So it's very important that you get in that program, you take responsibility for your part in what happened and how you got to this position so that you're never in this position again. You're obviously already signed the paperwork and understand that you will be required to register as a sex offender. If you don't register timely, then that's a violation of your probation plus another felony offense. And so you've got to take care of everything you're supposed to while you're on this probation. So the good thing about that is it's a deferred probation and there's not a conviction. The good thing for me and potentially Ms. Malfino later is that by doing this deferred probation, that cap of 6 years is off the table. Okay, that's over today. I didn't give you prison time, so that's gone. If you violate this probation, I then have the entire punishment range, which is 2 to 20 years in prison if you violate. So there's no coming back and saying, I want the 6 years or I violated and I've got the whole range. I'll look back at this and I'm sure I'll be reminded at what their argument was, and it's not likely to be 6 or less. You understand? So I'm going to hand you the trial court certification that shows this was an agreement that I followed. And so you've waived your right to appeal. Now, obviously, a part of this probation is that you have absolutely no contact and no communication with the victim. And so if there's some relationship that you're still having with her mother, it cannot be at a place where she is. You cannot go to wherever she's working. If you go into a restaurant and then she comes in after you, you're the one who has to leave. It's up to you to remain away and not have any contact or communication. You understand? Yes, sir. All right. Good luck. Thank you, Mr. Lewis. Sorry, that goes with that. Mr. Jeffries? Mr. Jeffries, you have Jesus Ibarra. Morning.
I was able to get his first yesterday.
Oh, good. Good morning. Good morning, sir. You're Jesus Ibarra. And this is 23 DCCR 2253. Mr. Ibarra's case is set for trial to begin with jury selection next Monday. And what is the announcement?
We'll be ready, Your Honor.
Right. All right, I want to go make sure, let's see, what was the previous, has there been any other negotiations or offers?
It was a cap of 8, Judge. I did let Mr. Jeffries know in docket yesterday before he met with his client that I was open to having further discussions. It's my understanding that it doesn't change.
All right. So I want to make sure you understand, Mr. Ibarra, it's likely your case will be the #1 case for next week, and there will not be any plea agreements accepted after today. Do you understand?
Yes, Your Honor.
All right, and so you want to still go forward with your trial next week?
Yes, Your Honor.
All right, we'll see y'all next week. I will number the cases and let you know after docket, but I anticipate this will be the #1 case.
Yeah. I may ask if I could get maybe a protective order. I'm on a trial docket in Polk County as well, not #1, but I'm there.
We'll get that done as soon as it's numbered after docket. We'll get you protection so that you're here since your client is it anything older or a kid case or anything like that up there? Okay. All right. Then we'll make sure and take care of that so that you're good for next week.
Thank you, Your Honor.
Thank you. Just make a note to get that. Ms. Holmes, you have Christina George.
Shannon, we could hold on that one
Sure.
I'm ready on Mr. Frazier.
Okay. Jacobe Frasier?
Yes.
Got it.
I'm ready.
Good morning, thank you.
Yeah, that's.
All right, are you Jacobe Frasier?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Frazier, in cause number 25 DCCR 0732, you're charged with the third-degree felony offense of obstruction or retaliation from May 18th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Freely.
Okay, did anybody force you to plead guilty? All right. I have here on the computer some documents that have your signature on them that it looks like you went over with Ms. Holmes. Did she explain those documents to you before you signed them?
Yes, ma'am.
And do you understand those documents?
Yes, ma'am.
And do you understand if I follow the agreement that you made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 4-year deferred probation.
With 5.
There's 4-year probation and then a $500 fine. Does that sound right?
Yes, ma'am.
And you understand as long as I follow that agreement, you can't change your mind later.
Yes, ma'am.
Okay. And are you a U.S. citizen?
Yeah.
Okay. State tenders number 1.
No objection.
It's admitted. Any evidence that Mr. Frazier is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, but I'm going to reset your case so the probation department can do a pre-sentence report. That'll give us more information about you and your case, and then we'll come back later for sentencing. Ms. Malfino, what is the state's
I have no
position?
objection, Judge. He has one misdemeanor evading. I think the PSI will probably come back and show us all maybe some specialized caseload.
Sure. So, Mr. Frazier, if I reduce your bond, where would you go live?
6655 Al Street in Gross, Texas.
Who do you live with there?
My grandma and uncle.
Okay. So here.
Actually, grandma owns a house, but she stays there most of the time.
Okay. So do you have transportation to go to probation and things like that?
Her name is Charlie. She works at Motiva. Yeah, brought me to court, but tell me to come back, but I didn't come back. But she'll bring me.
Okay.
And I cut grass. I have my own lawnmower.
Good.
Weed eater, I couldn't use it, so I gave it away for free.
Okay. I don't want there to be any issues with showing up for the pre-sentence for that interview. So I'm probably going to leave everything the way it is so that we have a good plan in place with that pre-sentence report. And then that way, hopefully there won't be any issues and we'll have all the rules in place. Okay. So I'm going to leave everything the way it is now. We'll see you back here in just a few weeks. And then at that point, you'll get out and be on probation. Okay. All right. Go back with the bailiff. Mr. Lewis, you have Robert Eaglin.
Robert Eaglin?
Good morning. Are you Robert Eaglin?
Yes, ma'am.
And this is 24 DCCR 2382. Mr. Eaglin's charged with aggravated assault with on a family with a weapon, and case set for trial to begin with jury selection next Monday. And what is the announcement?
Judge, the state needs to announce not ready. I have spoken twice in the last week or so with the complainant. She had a stroke. She actually called me from hospital.
Okay.
Tell me that she had just had a stroke. She has to do some therapy to be able to be in a position where she could clearly testify. She is cooperative. She understands the ramifications. She's checked in again yesterday, nervous about what my announcement was going to be. The court will see that case. The offense date looks a little bit older. It was originally in CBC. Mr. Laird had it. they could not locate her. At some point, it was then dismissed. When they did locate her, when she saw something on the news or on social media, it was refiled, it came here, so it's actually just been through maybe a setting or two, and this is a first trial setting, so I would respectfully ask for, it continues to allow her to rehab and then be able to.
Okay, I will grant that, and we'll reset it to the next available trial docket. If there's any issues or motions that need to be filed before then, just let me know.
Okay.
Okay,
No problem.
all right, you can go back with the bailiff. Mr. Rojas, you have Marco Gomez.
I don't know if we need him. I'm just gonna be asking for a reset.
Okay.
Issues with videos.
Why is this one so old?
He got deported at one point and
Okay.
thought it'd
So
be a good idea to come back.
with this pending? Yeah, well, job security. Any,
Judge, Mr. Rojas was looking for a specific video, so Karen was working on that this morning to get that form. To make
Okay.
sure, because it's a little bit older, some of the videos are different formats. We weren't able to download them like we normally would.
okay,
So she was getting that form and should have it by the end of the day.
all right, we'll just do a normal reset to give you time to get all those and go over them with your client.
Thank you.
Thank you. And then, you're good. Mr. Nichols, on Jetson Bell, which is actually Mr. Smith's case, that's set for trial next week. I'm obviously going to take into consideration the circumstances. Mr. West is in Tyler County and did announce ready.
I know there's multiple cases. If we need to get one together, we can, Judge. I know Phil's got everything ready.
Okay, and there, I mean, I would appreciate that. I might number it, but just because of the nature of the offenses, I would think y'all could throw it together. Okay, not throw it together, but get one together
I know
based.
we have them prepared and
I mean,
there's several cases, so we'll pick one that's.
You've got an evading and an unlawful possession of firearm by felon and a possession, all from the same stop. So, all right. Thank you, Mr. Nichols.
Yes, Your Honor. I need to try that.
Okay. Under. Ms. Holmes, you're working on George still? Christina George?
Christina George.
But it has charges that have not been indicted, but she has been indicted on another charge that's not in the motion. So she's playing many different.
I did not see this
NTRP.
little note that he had on Jetson Bell. The main officer is wife is having a baby this week.
I mean, some people will do
I
anything
know,
to get out.
anything to get out of trial. So I don't think he won't be available. So
I will not make. Well,
preparation, I promised I will retract.
That's okay. That work. I mean, it works out with Mr. Smith and with.
What can I do?
What can? All right. So we'll go ahead and reset Mr. Bell then off that trial docket, not off the trial docket to the next trial docket. So on. If there's a new, I'm inclined if there's a new offense that has been indicted that's not in the motion, I would think there should be maybe an amended motion that comes so that we can go ahead and include that in everything.
There was an email, this will go on from probation, followed up with Carlton County, and they stated that they, as of June 30th, had not filed anything further pending, which you can read either there's nothing pending or there's only one thing pending. So it's a drug case. So I don't know if they're saying, well, it's not pending because we don't have a lab back, but
But you think it's been indicted now?
Yeah, she said in the email, she said there's one, she was indicted on March 27th for a second-degree felony possession. That it was set for court in July, but that offense differs from the offenses listed in the MTRP.
Okay.
So the offenses on the MTRP have not been filed.
But there is one that
But there was
has.
one that was indicted in March.
Okay. I feel
It
like,
makes sense because the ones in the MTRP are from 2004 and the March is
24.
2025. But
Yeah.
so what let's just do, I'm gonna reset it one time. Ms. Malfino, if y'all will get an amendment done, just so that when there's pleas or truths or not true, it's to everything that's out there and there's not any question. I mean, if the other ones aren't coming that are old from 2024, that's fine. But if we've got one indicted, let's go ahead and get it in the motion.
And I know last time she had been hesitant to go to treatment. I will reach out to them and ask if that's something that is ordered, that would concurrently take care of
that. Okay, that would be great. Thank you. All right, we'll get all that tried to, so everything kind of happens at one time, hopefully. Okay? All right, go back with the bailiff, please.
Thank you.
Ms. Perazzo, you've got Avon Johnson. It's a sentencing hearing.
Yes, ma'am.
Good morning. How are you?
Good, how are you?
Oh, it feels like a Monday times 10 on a Tuesday.
Yeah.
Monday, I'm 3 people today. And son decided he needed to pick up the pit bull puppy on the side of the road so it didn't get run over yesterday. And I've been up all night.
Oh, okay. And they cry like babies. I've raised two.
All right, sir, are you Avon Johnson?
Yes, ma'am.
And this is 24 DCCR 2044. Mr. Johnson was previously in court, entered a plea of guilty to the offense of arson, intending to damage a habitation or place of worship. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Yes, Judge.
Any additions or corrections?
So no corrections, but there is an issue. Ms. Malfino and I have spoken about this. On page 2, at the very top where it says restitution issues, it looks like there's an outstanding bill, if you will, for repairs in the amount of $150,000, but I don't know if that's the actual case. I think that those,
And I would agree, Judge, if I may, Lori,
Sure.
that figure came from the fire department, not from the apartment complex.
Okay.
The apartment complex may be under governmental control and that may have taken care of the issue. With
Well-
respect to what Marshall Hurdle said in the PSI, I know him very well, actually, and he didn't understand some of the predicament I was in with respect to the complainant that I had let the court know in advance about her mental status and cognitive ability to testify, et cetera. If you would like me to take a deeper dive into where that restitution is owed, if any, that's obviously way substantial amount to order Mr. Johnson. I am concerned about his behavior.
Well,
while awaiting
I'm
sentencing.
concerned about his behavior, but I'm just as concerned about the fact that he
Then it
denied the
he blamed it
offense.
on her, Right.
yes.
So if you didn't do it, then you shouldn't have pled guilty. And so that's what a jury's for, to come in and decide if you are guilty or not. This says, at least what they put in here, that you said that there was a bottle of lighter fluid on the floor, that she flicked a cigarette and the fire just started, which is different than that's obviously not arson, that's an accident. And so we've got to get past that before we do anything else. So either you did what they charged you with, which is starting it in anger or whatever else was going on, or not. So did you do it? Did you not do it?
I wouldn't say I did it, but I would say that contributed it to we were kind of wrestling. It just happened.
Again, that sounds like an accident, not arson. Because here's the thing, I mean, a 5-year deferred probation is a great deal. I mean, you don't have, I mean, well, I say that, you do have criminal history and a revocation. So I don't know. Anyway, if you violate your probation later and you're back in here on a motion to revoke, I mean, it's a first, right? I mean, you're looking at 5 to 99. And if I say, you know what, I think you deserve 25 years in prison, you can't say, well, I didn't really do it back then. I shouldn't have pled guilty. So you're stuck. So either you did it or you didn't do it. You know, when you were here before, you were standing in front, you stood in front of the clerk, you took an oath, you said, you're going to tell the truth. And so telling the truth is either accepting responsibility if you did it or saying it was an accident. And if it was an accident, it's an accident.
I played out to, I played guilty to, and I accepted the charge for arson.
Mhm. Okay, all that's great. Did you do all of that because you're guilty of the offense? Okay, so I guess what we need to do at that point, then I don't mind. The only problem is I need to have that restitution before sentencing.
Sure.
But I don't want him, if he's getting a deferred, he didn't need to be sitting in jail.
An idea might be, if I may, Judge, to order not to exceed that amount. I will confirm, and then we can
Sure.
drop it to.
Yeah, that's probably the easier way to go ahead and get it sentenced so you can get out. Obviously, I wouldn't expect that it would be anywhere near that, though. I mean, that would.
If you understand my position.
Sure, absolutely. I do. Yeah. And then if you, if there's an issue when the restitution amount, if any, comes out and we need to have some type of hearing on that, then we can still do that even though he's sentenced if I do a not to exceed amount.
Yes.
So do you understand, Mr. Johnson? What I'm going to do is go ahead and give you the probation today. I'm going to order restitution not to exceed $150,000. No one expects, I don't think, for it to be that, or maybe who knows what, maybe not anything, maybe much lower than that, depending on insurance and whatever else. If there's an issue with that, we can handle it later, but that way we can get you sentenced today and you can go ahead and be released. Do you understand? Now, if there is restitution, and you will be required to pay it on that probation. So it's really important that if there is any order, that you start making payments on whatever it is every single month, even if it's just a little bit, to show me that you're making those payments, okay? So what I'm gonna do is find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney. Defer all proceedings for a period of 5 years. There will not be a fine in your case. There will be restitution ordered in the amount of not to exceed $150,000. Now, I have a note here that if I accept this agreement, there might be something else I do because of your jail incident reports. You know, I mean, you were just in a fight in July out there. June, talking disrespectfully to, I'm not real sure what's going on in the jail to make any of you that are sitting in jail thinking that the correctional officers are going to somehow have anything to do with you when you get out of jail. I mean, really, you think that's where you're going to meet your next girlfriend?
No.
Then you shouldn't be talking to them like that, right? I mean, you threatened one male officer that you were going to beat his ass.
Say something.
I don't know. You probably shouldn't. How old are you?
32.
You're too old to be acting like this. This is the kind of stuff I'm getting on the little young punks out there. You know who I'm talking about. All of them that are out there acting like heathens. That shouldn't be you. You're not doing near as much as all them, but I shouldn't be having this on somebody that's in their 30s. I mean, you've already been on probation and know what it takes to be on probation and didn't do it. So I hope that by going forward today, you understand, just like I said, if you follow all of the rules of this probation, great opportunity, right? You don't have this conviction on your record, you get out, you live it like the rest of us. If you violate any condition of probation, you're brought back into court, you become a convicted felon on this case, and I have the whole range of punishment, which is 5 to 99 or life. And I'm going to look back at that time and see that I gave you an opportunity on probation when you just revoked a probation 2 years ago. And so it's probably not going to be some little mountain prison and you just get to go on your way. It's going to be, you need to start learning from your mistakes kind of thing, right? Makes sense? All right. So I'm going to hand you the trial court certification that shows this was an agreement that I followed. So you've waived your right to appeal. Probation will give you some information today before you leave. Make sure as soon as you get out, first thing you do is go to probation. Okay. All right. Good luck.
Thank you, Judge.
Thank you. So many lectures that don't matter today. Okay, Mr. Cashin and Mr. Johns on Larry Williams. Good morning, Mr. Johns. Good morning, sir.
Morning, how are you?
Good, how are you?
I'm good so far, so good.
Not me.
Good morning, sir. You're Larry Williams?
Yes, ma'am.
And so we've got two cases with Mr. Williams. Cause number 25 DCCR 0985. Mr. Williams is charged with capital murder. And Mr. Cashin, you represent him on that case.
Yes, Your Honor.
Mr. Johns was hired to represent Mr. Williams in cause number 24 DCCR 1790, which is the aggravated assault causing serious bodily injury.
Yes,
We're here today on an announcement. Mr. Cashin has filed several motions. And so a couple of things that I feel like we could probably handle today, and then a few things that I'm going to put off to another day. Most of those motions, I think, were filed Friday.
Yes.
Mr. Smith is the Assistant District Attorney on the case. You can talk with Ms. Malfino this morning. She'll kind of fill you in on how, I guess let me go through the first thing with regard to discovery.
Yes.
And how you get that here. There's a portal. It's very easy. The state is very easy to deal with. They'll give you access to that portal. If there's any media in the case, there's a different request that needs to be made for that. Ms. Malfino can sit with you this morning and explain how all of that goes. So with regard to it, this time discovery, I'm not going to rule on any discovery motions. It's automatic. It's with Michael Morton Act and everything else makes it where they're going to give you everything they've got.
Yes.
And so if you find after you visit with them and you get everything off the portal that you feel like there is something that's missing, then bring it to my attention, bring it to their attention first, obviously. And if there's an issue that you feel like you're entitled to something that they're not turning over, then we can have a hearing on that at that time. So the next thing that I do want to go through and rule on, at least today, is that motion for a gag order that was filed some time ago. And so everybody's had a time to take a look at that. I'm going to, Ms. Malfino, I guess let's start with you. Obviously, I understand Mr. Cashin's position with regard to that and his motion. What's your position?
I do as well, Judge, and I think the court is aware, as long as you've known me, myself and Mr. Smith, it's always our best practice policy not to speak to the media or anybody while a case is pending. If that, I have no objection to that order, and if it is granted, I will be sure to send out a memorandum to my office.
Yes.
Letting them know it has been granted and that they need to.
Sure. And I don't have an issue with the district attorney's office. The only issue that I have is the sheriff's office.
Yes, ma'am.
Because I don't think the sheriff, typically, as everybody knows, gag orders are not deemed constitutional. Obviously, there's exceptions, and Ms. Malfino agrees in this case with regard to her office.
Yes.
I will gladly ask the sheriff's office, but I don't think I'm in a position to order them. They are not a party, as the attorneys are. And so I'll let you make argument if you'd like, but I'm not inclined to grant a gag order on someone that's not a party. I don't think constitutionally I can do that.
I understand, but I just wanted to point out to the court that certain people in the sheriff's departments, I think they have podcasts and they go on the media and then they give their opinion about this case that is presently pending, which I kind of think taints the jury pool if we end up in a trial. And
Do you know who that is? Somebody who has a podcast currently about this case?
Well, I've seen sheriffs speaking about this case on different broadcasts. If I need to be specific, I will locate those particular, or that particular.
If you don't mind doing that, and you can, if you would, you can just email myself and Ms. Malfino, Mr. Smith, because I don't mind at least starting with a request to them not to do it. If I feel like what they're doing is in some way going to be detrimental to us being able to get a jury, then I will look more into that. I don't know, again, the constitutionality of it. I would have them probably show up to a hearing with their legal representatives and we can handle it that way. So let's do that. At this point, I'll grant the motion in part with regard to the district attorney's office and obviously with regard to you, Mr. Johns, and anybody and everybody's, y'all's respective offices. And then send me that and whatever information you can find. I'll talk to the sheriff's office. I have a feeling they won't have any issue with my request. And so, but if they do, then we'll talk more about that. So then that's that.
Also, Your Honor, I think some housekeeping matters that I think are very important is in regards to the indictment and the way the indictment.
Yes, so you filed a motion to quash the indictment. I did take a look at that. I honestly saw the same issue already with the indictment. The style or the heading of the indictment legally is not necessarily indicative of the most important part, or it doesn't, what's the word? The body of the indictment sounds correct in this case.
That is true.
The state has become aware of that. It should say A2 instead of A10. They are going to get that taken care of. And so that way it looks correct. It's correct, obviously, in our system as well, which can become an issue just because of our system.
And I just want it to be correct.
I totally agree. And that's the only issue was the A10 to A2, correct? Okay.
Yeah, that's rather important.
It is. The body, though, I did read the body and it looks like there's not an issue, but we'll make sure that the Ms. Malfino.
And Judge, having not worked with this gentleman previously, I would be happy to make an oral motion to amend if you would prefer. That we follow that up with a written motion, just so it's cleaner for the court.
I think I'd rather, just because of the nature of the offense, because it's a capital, if we just do that, if y'all would do a motion in writing. And that way we've got a paper trail in the file that shows there was a motion that's and I'll grant that and make that adjustment on the indictment.
Just want it to be accurate.
I don't disagree with that at all. So they'll get that taken care of, I'm sure, very soon.
You found, sir, so
Okay.
if we can exchange emails, I can be sure that it's served.
It looks like the other things that were filed have to do with mostly discovery issues, a list of persons to contact or interview, some things like that.
That to me, Your Honor, is important because after reading the probable cause affidavit that's attached, it indicates a lot of he said this and she said that, and
that's one of those things that I would say, get with the district attorney's office. Obviously, I would think anyone that any detectives or officers talk to or interview would be part of required discovery.
And I would like that, kind of early on instead of later on, because those people need to be interviewed.
Sure. I mean, whatever they have, you'll get.
Thank you.
And then if there's anything, again, that you feel like is not included,
I will
bring that to their attention first. Let them contact the agency, see where that stuff is and how quickly they can get it. And then if it becomes an issue, let's get back on that. The last thing that I see that I'm not sure, there's a motion for preservation of personal notes.
Of the office, the police office.
Okay. Ms. Malfino, have you had an opportunity to take a look at that? I really haven't, as far as,
Really haven't, Judge. I know that.
I would think personal notes might fall into some type of work product. I mean, their reports obviously will be turned over.
Exculpatory. Yes, I would agree that, that information be turned over. I would assume it would have then been placed into a report.
Right.
At some
Mr.
point, I
Cashin?
would argue that some of that is work product, personal notes of correspondence between us and the officers in preparation, et cetera. I would argue is work product.
To me, the personal notes are attached to the people that have been interviewed, because the officers, when they go out and interview people, they may take personal notes, because in the probable cause indictment, it said that they had spoken to certain people who said that he had a gun on a particular occasion, certain people that said he did it, and those are the people that need to be interviewed, and the personal notes of the officer relates to those things.
And Judge, if I may, I think he may find when he requests the media that majority of those interviews
On
might
body
possibly
cam.
be on body cam or having someone come into the police department.
Right.
It's not so common practice anymore for the transcript, so to speak, of that interview to be recited then in a report. So it may reflect in the report, I spoke to X and he hasn't seen the recorded interview, which would obviously make a big difference.
Okay,
But that's the type of information I was leaning toward.
sure. And I think that's probably, let's do
And with
this.
the nature of the case, I need to cover my bases.
Absolutely, no, yeah, I would totally agree. So today, what I'm going to do is hold making a ruling on the motion for preservation of personal notes. The motion for discovery, obviously, that's granted, you get all of that, work with them. Anything in the person's interviewed, let's go through the discovery process first, the way with the portal and everything. If there's anything that comes up that you feel like you're entitled to that they are refusing, then we'll have a hearing about that and work that out. The last thing is there's a motion to reduce bond that was filed on Friday.
Yes, ma'am.
And so, Ms. Malfino, I'm going to ask, is the state ready to proceed on that today, or do you need some time or to get Mr. Smith available on that one?
Well, and I'm happy to cover it, Judge. I don't need a lot of time. I would prefer the ability to get at least the lead detective here for the court.
Sure.
The instance that you or counsel would have any questions with respect to that. And I'm not necessarily saying we're opposed to some type of relief. I know what the bond is set at now, but I think due to the nature of the case,
Sure.
as counsel has stated as well, I think it might be beneficial to have just a very short hearing. I can be prepared on that as early as next Tuesday, Judge.
Okay, so Mr. Cashin, we can do a couple things. I think just because it was filed kind of late in the game, I want to give them just a short amount of time to get prepared on that. We typically have Tuesdays are our jail dockets. I'll be in.
Or maybe the next week, since we're going to be in trial next Tuesday, we won't the following week because of Labor Day.
Right.
That would be great.
Mr. Cashin, I'll let you choose next Tuesday or the Tuesday after.
Maybe on my calendar right quick.
We could do it next Tuesday. Do we have one already set at 11 next Tuesday? We'll do a lot of these types of things at the end of our Tuesday dockets. We might have something already. We do not. So we could do it either or next Tuesday or the Tuesday after.
Tuesday afterwards might be better. September 2nd.
September 2nd?
Yes, that'll work better for me because I have several matters next.
Sure. Okay, then we will set the motion to reduce bond on the 2nd. And if anything comes up between now and then, we can discuss all that as well. And especially if, Mr. Cashin, if something comes up after I visit with the sheriff's office with regard to any information that you emailed us,
Yes, ma'am.
then we can maybe have them here on that day possibly to take care of that part. But right now I am granting the part of the motion for gag order on the attorneys only.
Yes, ma'am.
Okay, anything else we need to handle today?
I think that covers
the status of my case with him. Prior to these new allegations, we had come to a proposed plea bargain agreement, Ms. Smith.
I want, at this point, I don't think it's appropriate for me. I'm not going to accept any plea agreements
I
on that
understand
case.
I'm just kind of giving you the background.
Sure.
Let you know, I have been talking to Mr. Smith. I talked to him last week in reference to this case, some of the suggestions that he made to me. I really don't know where to go forward with this situation. So I would ask for more time and see what's going to.
I think that, sure, and I think what we'll do is carry the two, they're obviously not on the same date cases, but they're related. And so the cases will be carried together on all of the dockets. And if, on next Tuesday or the Tuesday after, that's really a motion that Mr. Cashin has filed that we're going to handle. If you want to be here for that, you're welcome to. I don't think legally you haven't filed anything that we would be hearing on that day. It would be the bond reduction. But typically on announcements and as we're preparing to move forward in the case, I would expect you both to be here. Both cases will kind of travel together and then we'll see where we get.
To add to that, I appreciate you saying I don't have to be here next Tuesday. I'm at the stage in my life with my mother. I'm blessed to have my mother at 94 years old. And you probably can make an anecdotal effect that I'm pretty much steady going to be in court when I'm supposed to be in court. But because of that, I'm having some issues and I'm not getting where I need to be getting it. The secretary's gone. So I'm having a few little anecdotal issues right now, which I haven't had the last 30 years.
We'll make sure, again, on the second, you don't need to be here on that one. After that, you'll get notice of obviously every announcement and things like that. And so if you're having an issue, just let us know. If it's something that's just an announcement, it may be something that you can visit with Mr. Cashin. If there's nothing that's taking place and you're having an issue, we can still move forward, at least with moving the cases along. All right.
Thank you, Honor.
Thank you.
And that's one other thing that in reference to discovery issues, the discovery portal is absolutely fantastic dealing with. But these TFI files that they file instead of using the PDF files, they change. We're almost impossible to open them. Okay.
All right, so I don't know the letters you're saying, but get with Miss Malfino and Mr. Smith.
She can't fix
anything. I'm sure that if there's any issues that you're having with a specific file, they'll get that for you. Just get with them.
I don't know if that's possible. They might have to go upstairs to the computer department. Thank you, Your Honor.
All right, yes, sir. Thank you, Mr. Cash and Mr. Williams. You can go back with the bailiff. Yes, sir. Nice to meet you. And I just printed that. I'm going to sign that gag order.
Rock and roll. Okay, and you are Desmond Jerome Papillon Jr. Okay. Okay, in this case, you have been indicted for the state jail felony of unauthorized use of a motor vehicle in 25 CR 780. If convicted of such a thing, it carries with it up to 2 years in the state jail. And here, put you down in there. Feel like I'm in school now. Langston's mother would get you on that. Being the educator she is. And anyway, it carries with it up to 2 years in the state jail, which is serious. And it's a state jail. It's a felony offense. You've never been convicted of a felony before. You don't want it. You know how long that straddles your back? The rest of your life. So it needs to get fixed, and he can do it. He can help you. How much time do you need? 4 weeks? 4 weeks. Okay. Get a resetting. Thank you, Judge. Get a resetting break here, sir. Thank you. I'll get you out. Paris. Easier. Ross. Mr. Ross. He is here, Judge.
Yeah. Mr. Papier, you got to come here outside.
Let's see, what are you wearing? Let me ask you this. Would you wear that to church? Would you wear it to church? Maybe you would. But this is, look at everybody. Everybody's got it. All the men have ties and the ladies are dressed. This is a place of honor. We're talking about the Constitution.
Yes, sir.
It has its reverence and its humility. And its integrity. You don't have to wear a tie or anything, but just not a bright T-shirt that's got some kind of a message on it. I can't even read that. What's that saying? Does that say something up there?
Godspeed.
Godspeed. What's down below? Let me see. It's a car, vehicle. What is it? Oh, it's getting gas. It's a gas guzzler, I guess. It's a gas guzzler. Looks like a Datsun or a foreign car, sports car. All right. Just dress decently. Yeah. All right. You were charged with some serious offenses here. In 25 CR 381, you were charged with the second-degree felony of fraudulent possession or use of credit or debit cards. If convicted, this carries with it up to 20 years in prison. 25 CR 382 is not much less of a serious felony either. It alleges that you committed the third-degree felony of forgery. Looks like it must have been at the same in the same episode.
Yes, sir.
They carved out two crimes. Third-degree felony carries with it up to 10 years in prison if convicted. So you're looking at up to 30 years in prison if found guilty on these cases. This is an admission.
Yes, sir. I just want a little bit more announcement.
4 weeks good on this one too?
Be good.
I don't see a criminal history here, right? You don't have a criminal history?
Yes.
Yeah, felony. You have a felony in this county?
No, sir.
Okay.
I'm not from Texas, Austin.
I see you're at Atlanta, Georgia.
Yes, sir.
Well, that's you need to navigate through that. Whatever your convictions are in Texas, you lose opportunities for probation if you've been convicted of a felony before, depending upon the circumstances. He's a smart guy. He knows how to navigate through all of this. 4 weeks.
That'll work.
Okay, please get a reset. Thank you.
Thank you, Judge.
Yes.
Before we go outside. Yes, and
I don't see Mr. Grove. James Paget, are you ready? Are you working on something?
No, I'm not. I have a few Ballard. I actually have 2 cases on the dockets.
Kia Ballard or Bilal.
we'll see. Thank you. I don't know. One sometimes we'll see.
Kia Ballard.
It should be in the hallway. Okay, excuse me.
Oh. That's let's see. Who's the lawyer? I don't see.
See one either, Judge. I haven't picked one to this time yet. It's.
Really?
I want to say
Nobody wants to prosecute this, I guess.
I'll have my motion filed.
That's you got it, buddy. You don't need to write anything. Just tell me.
I can make it a moral motion?
Yeah, it's good enough for government work.
Well, I know there's something well. Never mind. Stop right there.
Okay. Kia Ballard or Ballard.
Look at you, just telling. Judge, look here.
What happened?
It's very honorable. He's just stepping up.
It looks like he's the American flag too, by the way. Yeah,
Right there.
he's got the flag on you. He's waving the flag.
How are you? Good seeing you.
Good seeing you.
Kia Ballard.
Hiya, Ballard.
Kia Ballard.
Hiya.
Kaya Ballard.
Yes.
Miss Mel. Everybody do it that way. I don't mess it up.
The name is a big trick.
You are indicted here in 23-41367 with the state jail felony of abandoning or endangering a child, which if convicted carries with it up to 2 years in the state jail. And it's a felony, which you don't want.
Yes, sir.
That a felony conviction, you have to carry with you the rest of your life. So that closes a lot of doors of opportunities and privileges that you don't want to close.
Yes, sir.
Mr. Paget, very good lawyer, and he knows how to help people. What are we going to do today?
Here's where our issue comes in, Your Honor. It looks to me like this is an extremely old case. So, this is my first appearance.
You won't believe this, but I got some in the 20s.
I do understand that.
20s. So
she hired me just a short time ago. I filed the proper documentation.
2.5 years.
Right. But as soon as she hired me, I filed all the documentation. I filed on 7/12, my letter of rep. I'm in the process now of reviewing the body camera footage and the dash camera footage.
What is your address?
Mine,
Yes.
2680 Morris Street, Beaumont, Texas.
See, generally, when we have an issue like this, the address, they've moved from the address that was given at the beginning, but
You're not
she
in
didn't.
trouble. He's just making an option.
She didn't. I mean, this is the same address. I wonder what, I mean, this was indicted in January of 23.
Your Honor, I can only speak from like 7.
When were you, when did you receive a copy of this? Do you remember of the indictment? When did you find out you were indicted? Recently?
When I went to jail,
When was that?
March. I was about to say March, I believe.
This year?
Mm-hmm.
Wonder why it took.
I didn't even know when I got
I mean,
pulled over.
that's your address. They normal, and it was indicted in 23.
Because I remember when I went to jail, I got out on accusation,
Oh.
and then I never heard nothing about them picking it back up. So I just assumed it.
You mean, okay, that was originally, that was in 23?
2022.
2022.
Yeah, the end of September 2022.
September 22. I don't know what happened on that. That's weird.
So I'm working diligently
from the beginning. You're starting.
And, well, it won't take me. If you would give us 30 days, I'll be ready. I have
5
an offer
weeks.
from the state.
5 weeks.
Whatever, please.
All right. You got 5 weeks.
We're moving. And I had a good pace on the case. And I have an offer.
Have you been convicted of anything before, man?
She has not.
Nothing.
Now, she does have a failure ID out of the same transaction, which I'm going to step down to the involved shortly.
Well, again, that's fixable.
Understand.
We offered deferred, Your Honor, so we'll see what they have to say, and they may work it out.
Okay. Good, because you don't want a conviction, felony conviction.
I really don't.
Yeah, there's a way.
Getting a medical field.
Oh, good for you.
Yes.
Good for you. My daughter is
Yes.
manages hospitals, and
Oh, yeah, that's what I want to
you
start
help
out as an
people.
RN.
You help people. Yeah. Are you an RN?
I want to start out as one. I don't want to.
Where are you in your medical field?
I'm
In
not
nursing.
yet.
Oh, you hadn't started.
Get there,
Well,
but
one step at a
finish
time,
this
and you get
first.
there.
Yes.
In the right direction. Well, you know it. Okay, good for you. Okay, please get a resetting from that lady.
Thank you, Your Honor.
Thank you.
Quinteller Matthews.
My understanding, I received a call from the bonding company this morning. I have not verified this myself because I haven't got a response from her. The bonding company tells me that she was contacted. They were contacted by family this morning and she's in the hospital. The bonding company, the gentleman I have a good relationship with, I'm trying to get, I'll call him. Okay.
All right, thank you
The
so much.
bonding company, we're trying to get documentation now that she is currently hospitalized. I cannot vouch for that because I haven't been.
I understand.
So it was an early phone call I got from Bell America.
In 25 CR 271, Quinteller Lachey Matthews, the defendant was indicted on February 26th of this year for the state jail felony of theft. And looks like this occurred at Marshall's here in Beaumont.
That's correct, Your Honor.
Nice store. And then the problem is that she has, according to this, 7 prior convictions.
I would agree with that.
7 felony convictions of theft. All out of district courts of Jefferson, Hardin, Fort Bend County. Okay, so paragraphs 1 and 2 constitute, she's in a situation where if she steals a pack of gum, it's a felony.
I understand.
So that's a state jail felony. There is no answer to Quinteller Lachey Matthews in the courtroom. I'm asking the bailiff to call into the hall for Quinteller Matthews, please.
Quinteller Matthews.
Interesting first name, family name.
I would have to agree with that. I haven't got into it that deep with her.
There's no response.
There's no response to the name called here into the courtroom and no response to the name into the hall. Defendant has failed to appear, maybe because of a good reason, but the court's going to enter findings that the defendant has failed to appear, and Mr. Patchen, on behalf of the defendant, has heard or has information that she may be medically unable to be here. But what we're going to do is order a, until such time we can get certainty, we're going to make a finding she has failed to appear. A warrant shall be issued for her arrest. What's her bond?
$7,000.
Then bond is doubled to $14,000, and a GPS device must be acquired unless the court receives information that she was unable to be here for a good cause. All right, that's that one. Is that it? Is that it? Well, he has two more?
No, he's done. Sorry.
Oh, okay.
What you meant, Jim?
Thank you. Looks like Kedrian Corbin of John West, Betty Handy John West, Jimmy Vin Wynn John West, and Ross Mac Owens have been reset as they have been reset to another date, or they have hired attorneys and we have received information of that. So anything else? Oh, we've got two other cases. Yeah.
Yeah, they took the videos. And you talked to Arson.
Okay.
I can just reset them.
Gania Delahousse, is that you? And Alan Lofton, is that you, sir? Okay. You're Jania Delahousse? And who's Alan Lofton? Okay, Ms. Delahousse, come on up.
Possible because the city is still safe. I'm also behind
Right.
You were Ms. Delahousse?
Yes.
And as you know, here in 25 CR 726, you were charged with the second degree felony of burglary of a habitation, which carries with it up to 20 years in prison. Very serious. Your attorney, Mr. Grove, is not here. And what's going to happen is
that is without prejudice. Thank you. Thank you. Do we have any other matters that are short matters? Because I'm about to start it. Nope. Okay. He's coming out. Where is? Who is, where's Mr. Burton Harris?
I'm here, Doc.
Right, oh, let's see over there. Probably grow. What I'm saying. All right, court does call the case of the people of the state of Michigan versus Anthony Blake Hamilton.
Here, sir.
It's going.
Robert Agasinski, appearing for the prosecution, Your Honor.
And good morning or good afternoon, Judge, to you and your staff. Robert Burton Harris on behalf of Mr. Anthony Hamilton, who is also present in the courtroom. All right, date and time set for preliminary examination. Are we ready to proceed?
People are ready to proceed, Your Honor.
Well, I think that depends on who you ask. So me and brother counsel have spoken. And it seems that the complainant, who is the subject of the charging document, and also the main complainant in this case, is not here. And brother counsel believes that he can proceed with the testimony of the wife. We disagree on that because
Wife.
the complainant's wife was also present. But this is our position is that this is an assaultive case. And I don't know how the wife would testify about her husband's level of fear or feelings of being assaulted. Because in this case, the complaining witness was not assaulted. So I don't know how the wife would actually testify to that, but brother counsel can speak to that, I guess.
Certainly she can testify as to what she saw.
Yes. That's correct, but I think that if
there's, quite frankly, if there's then a dispute as to what his feelings may have been or anything along those lines, and I'm not saying that the court's ruling that, but that may be an issue of fact for the fact finder, which would have the matter proceed. So are we ready to go?
We're still ready to go, Your Honor, with what we got.
All right, you can have a seat. Start calling your witnesses.
Yes, sir. They're out sequestered, I think, at this time. So I think I will call 4 during the exam.
Glad you turned that way.
I was told he was inside.
Inside.
I'm sorry, Your Honor. They're here.
You're here?
They're here, yeah.
All right.
The officer in charge has another case. It was in the meeting in a conference room, and he's bringing the complainant or the first witness right now.
Witness. All right. From where? All right, who is your first witness?
Yes, this is the first one. Listen, thanks, come right up.
And please come forward and be sworn.
Raise your right hand. You solemnly swear to affirm the testimony you're about to give you the truth, the whole truth, and nothing but the truth, so help you God. Go ahead, have a seat. State and spell your first and last name for the record.
While you got, I'm living in Berlin, while you got going to live my life.
All right.
Is that loud enough for the court?
Pardon?
Was she loud enough for the court?
Yes, she was.
Thank you. Again, what is your name, ma'am?
Living in Berlin.
And Miss Lynn, do you know who Mark West is?
Yes.
How long has he been your husband?
16.
Okay, he was your husband on October the 28th of 2024? What does your husband do for a living?
He is a professor at University of Michigan.
Okay. Now, did you and your husband on the date of October the 28th of 2024 go together to a Kroger parking lot located at 2641 Plymouth in the city of Ann Arbor, Washington County? Do you remember about what time you actually arrived at the parking lot?
It was dinner, so probably around 6 before 7.
Okay. And was it dark at that time or still daytime?
It was dark.
Okay. Did anybody go with you besides you and your husband? Okay. And were you going to the Kroger or what are the other stores in that mall area? Okay. And did you get out of your car and did you park the car and get out of the car? Okay. And what happened after that?
I drove, so I'm in the driver's seat, so I'm looking at my phone. And then I turned and looked over across the parking lot. A car was coming by as my husband was going to cross over, drive to go to Kroger. But the car came really close to him, where I think I may have seen his hand like, whoa.
Objection, speculation if she said she thinks she saw something.
It goes to weight.
That goes to weight, yeah. Go ahead. Overruled.
And then the car came in, and I think that really like took my husband off guard. And so I saw him come around
Around where?
back towards my car, where this car was pulling in.
Okay, your husband was walking away, had some interaction with this car, and then he came back to where you were.
Yes,
Then what happened?
I think he was wanting to say something to the
Objection,
gentleman.
it's
about-
called-
I'll sustain that objection.
Okay. Yeah, we don't want to have you testify to what he was thinking. If we ever get to him, he can tell us that. Just what you saw. So what happened as he turned around and came back to you, to your direction?
The car very quickly parked in his face and got out. The gentleman got out.
Okay, the car that had a some kind of interaction with your husband?
Yes, was, my husband. And the gentleman got out and said something. I saw them speaking to each other. At that time, my husband pulled out his phone and wanted to document something.
Okay, so you saw your husband pulling out his phone?
Yeah.
Okay,
The gentleman was being very aggressive. His body language was very aggressive towards my husband. At that time, I got out of the car. And then I said to the gentleman, "You almost ran over my husband." The gentleman, because I don't remember exactly what he said. He said something also to God as well. I did, okay, you're gonna film me, I'm gonna film you too. Then he took off into Kroger.
took off into Kroger.
Yes.
Okay, and was that close by, Kroger, to where you were?
No, because we were kind of maybe 20 cars into the park.
Okay. When you had a conversation with this young man, was it at the back of the car that he had parked?
Yes,
Do you remember what kind of car that was?
it was a light colored, like a 4-door,
Okay.
I don't know what it was.
I mean, you say young man, how about how old or young are we talking about?
I want to say 30 to 40,
Okay. Do you remember what he was wearing?
something dark.
Okay. So you and he and your husband all had an interaction, and then the man went into Kroger.
Ran into Kroger.
What happened then?
And my husband said, he almost ran over me. And at that time, he spat on his face. Because then I had to get out a Clorox wipe for him to, because it was in his glass and it was like all over his face. So I wanted him to wipe it all off.
So who spat on whose face?
The gentleman did.
Gentleman did what?
That almost ran over my husband.
Spat on your husband's face. Okay. At what point did he do that?
When he was exchanging words with him and when I saw that some interaction was happening, I got out of the car. So that had already happened.
Okay, so you saw your spittle on your husband's face and you gave him a Clorox to wipe it off.
Yeah.
Then what happened?
Then at some point, my husband said, he almost ran me over. And I said, I know, I saw that. And I was helping him, wiping everything off. And to me, I had the phone, I should have been videoing everything, but I didn't. Then a gentleman came out of Kroger as we were, and then my husband said, I'm gonna call the police. So he decided to call the police at that time.
Okay. They said the gentleman came out of Kroger. Was that the same gentleman that went into Kroger? And when your husband said he was going to call the police, was that before or after the gentleman appeared coming out of Kroger?
I think the gentleman came out and changed more words than my husband, and then he said, I'm gonna call the police right now. I'm calling the police.
Okay.
Then the gentleman said, go ahead, you call the police.
Okay.
And then he got into his car, slammed the door, decided to back out.
Who did that?
The gentleman.
Okay. Now, where were you and your husband at the time that he got back into his car and began to back out?
We were on the driver's side of his car because there was not a car parked on the driver's side of his car. And then my husband said, no, you can't. Yes, dumb. He was dumb. He actually went behind the gentleman's car and tried to stop him, thinking that he stood there, he would not back out.
Okay.
But no, the gentleman put it in reverse and then proceeded to back up quickly. So
Okay.
then he had to jump out of the way.
Okay.
He being your
My husband, yes.
Okay. Then what happened?
Then the gentleman in the car that almost ran my husband over decided, I said, honey, you gotta move out of the way. He decided to drive and swerve, almost hit my husband.
Now, you said your husband was behind the car
Yes.
and had to back out of the way when the man backed up.
So now we're on the left side of his car,
Okay.
right? So he backs up and then he decides to intentionally making it look like.
Intentional.
I'll sustain the objection, but you can tell us what you saw.
And what did you see? Bill, what did you see?
Then my husband had to swerve out of the way and kind of bumped him on his head.
When the man backed out and began to go forward again, how would you describe the movement of the car? Okay. Okay.
He sped out of the parking lot.
Okay. Now, have you yourself ever seen a video of that incident during the police investigation? Okay, I wonder if I could show you. This I need a few moments to set up, Your Honor. People's proposed exhibit number one.
All right.
My tech is way low.
Okay, that's fine.
So we're going to use this computer. Yes.
Should have a HDMI cord, you know what that is, that's underneath. That should plug
Barely, yeah.
computer. Let us know when you're ready, and then we can switch it over so it'll be on the screen.
Let me help you.
Oh, there you are. Thank you. To the rescue.
Now, it's okay, like, there's like 30 people in here. She is the only one kind enough to come up and help. There are 30 people that know. You want me to point at them?
Ms. Weidling, can I have,
I did warn your staff that I am going to be slow at this
Ms.
point.
Weidling, can I have a copy of this record where the court called me kind, please? Thank you so much.
Motion to strike granted.
Oh.
We'll be later.
Okay.
So Ms. Lynn, in a few moments, I'm going to have you look at a video. Will probably be on the screen.
Okay.
And then when the video is done, I'm going to ask you if that video depicts the incident you just described accurately. Okay? And that'll be my last question.
Okay.
Okay, for the record now, we have the video, People's Proposed Exhibit number one on the screen. So you had a chance to look at the video so far? And did you look at the far left of the video?
Yes.
Did you see a car?
Yes.
Did you recognize that car?
Yes.
How did you what did you recognize it as?
That's the car that went right behind me.
Okay, that's the car we're talking about that you claim was involved with your husband.
Yes.
It was on the left of the video as we're looking at the screen. Okay. Okay. They were playing the tape again. Is that him? So did you see a person running across the screen?
You said a yes.
Yes,
Okay.
And do you know who that was?
yes, it was John, I think that tried to,
So that was the gentleman you think was involved with interacting with you and your husband. Okay. Let's go again. It just falls back. Yeah, excellent. Did you see a few minutes ago the gentleman running back again? Was that the same gentleman?
yes.
Okay.
If that's forward a little bit.
No. So,
Look up here.
yeah.
Yeah, I'm not sure. Let me see.
Now we see a white car with the taillights on. Is that the car that we're talking about? Okay. Did you?
He's in the store. We'll have to walk back.
He's not in the store.
He is in the store.
Oh, I think so. Simpson. Okay.
No. He was in the store for a couple minutes.
Okay. We're fast forwarding a little bit. And him again?
No.
Okay.
You see?
Yep, I didn't see it. I didn't see it. Did you see it? Did you see your husband get hit? Did that get?
Right on the right.
Back that up just for one moment. See that again.
Think the incident?
Yeah.
Yeah, I did. I just sent it
Maybe
back.
just did because the white truck pulled down. I see.
So that's the, her husband that was just behind the pillar.
Can you get a little closer?
I
I'm trying to see if you can. Is that your husband's voice?
Yes.
Okay.
I don't know.
Is that enough, Your Honor?
Yes.
What happened after that? I guess I have a lot more questions. What happened after that? After your husband went, what happened after that?
Well, because he's trying to get out of the way of a car that's trying to run him over.
Objection.
So he,
Caught, sustained.
What happened
Murder.
between the two of you then after the car?
he got up, I helped him up. And then we waited for the police to come. And then another gentleman came who happened to be a witness
Okay, okay. Now, he was in the store for a couple of minutes, was he not? So what were you and your husband doing during that time?
He was talking to the police.
Okay, on the phone or in
Yes.
person? Okay. And did he give the police the license plate from the car?
I believe, yes, I believe he took a picture. I'm
Oh,
not sure.
that what he did with his camera, took a picture of the license
Yeah.
plate? Okay. Did he get medical attention after that? Where was he hurt?
Well, he just fell, right? So just very light.
Bruises? you
Yeah.
mean? Yeah. He didn't stay overnight at the hospital?
No.
Okay. Now, did there come a time after this incident happened that the police called you down to the police station to see if you could help identify who the young man was? And what did they do when you went down to the police station? What happened there?
Sent us separately in different offices and gave us a series of pictures.
Separately, you and your husband were,
Yes.
you're separated?
Yes.
And you were told to look at some pictures?
Yes,
Okay. Did you identify any of the pictures?
one.
Did you know whose picture that was?
At that time, I thought it was the person.
Okay. At the time you asked how certain you were, didn't you?
Yeah,
How certain did you say you were at the time?
70%.
About 70% certain
Yeah,
of the picture that you identified as what? Identify this person as what?
as the person who tried to run my husband over.
Okay. Had you ever seen that person before that date?
No.
Okay. I have no further questions.
All right, cross-examination.
You want this up here?
No. Where were you and your husband coming from when you got to the Kroger?
Something that. Chinese restaurant across the street.
Across the street? Does that restaurant, do you frequent that restaurant often? Do they sell alcohol?
Yes, they do.
Did you or your husband have any alcohol that night?
No.
You also testified about you hearing your husband say some things on the video. Is that correct?
On the video, which part?
Any part?
When I heard him scream, yes.
That's not the
Okay.
that's not the only thing that you heard though on the video. Is that fair to say?
Maybe I heard someone talking. I don't know if it's my husband.
You heard the other guy that you described as your words trying to run your husband over, right?
Yeah.
And he was screaming, right?
In my car or in the video?
In the video. In the video that you saw. Well, let's back up. On the night in question, when you were there, you heard the person that you accused of doing all this stuff yelling, correct?
Changing words with my husband, yes.
Is it fair to say he was yelling?
I think I said they were exchanging words. I don't know if they were yelling.
You couldn't hear what they were saying at all.
I was in the car.
So you said that you got out the car when you saw the initial confrontation with the guy and your husband, correct?
In the car, yes. The initial, yes.
And at some point you got back in the car?
No.
So you stayed outside the car from that point until the whole thing was over? And while you were outside the car, did you not hear the other person saying, "Get away from my car. Why'd you hit my car?" You didn't hear that?
No. I was busy trying to tell John that he was trying to.
You also said that your husband tried to stop the person from leaving, correct?
Yeah,
How so?
just by telling him.
He didn't physically try to stop the person from moving the car at all? Are you sure?
You're talking about when he backed up.
At any point?
And the only time was when he backed up. was trying to leave the scene.
So the other person comes back to the car, correct? They get in the car. You and your husband are standing right next to the car.
Yeah.
Your husband,
He's calling the police, he's on the phone, please right now, don't go anywhere.
so he's telling this person not to leave. And while he's doing that, he's reaching for his door handle, right? He didn't try to touch your car at all that you saw? Well, I'm asking about what you saw.
I didn't see him.
You didn't see him do that, or you didn't see him at all?
I did not see him do that. I was there the whole time.
At this point, when the person is getting back in the car, tell me specifically where you all are standing.
Next to his car on the driver's side.
Both you and your husband are on the same side. So your husband gets behind the car. Did the person driving the car just hit the gas and run your husband over?
He was backing the car up as if there was nobody behind him.
As in quickly?
Yes.
So did your husband have to like jump out the way to move
Yes, I told him to get out of the way.
as the car was backing up?
Yes.
Are you sure about that?
I said, honey, you have to get out of the way.
What I'm asking about, are you sure about, is your husband having to jump out the way while the car was backing up?
No, he had to jump out of the way when the car tried to run him over.
So when he's in the back of when the car trying to back up, your husband is blocking him from leaving, correct?
Yeah.
So you convince your husband to move, right? And at that point, after he moves out of the way, where does he go in relation to the car that's backed up?
The car is backed up. We are standing on the left front side of
The left,
in the parking space.
the left front side of his car. Are you talking about the person who you?
Passenger side.
So you're not directly in front of the car, but you're on the front passenger side in the front of the car. And that's because your husband is still trying to get him not to leave, correct?
Because he's still on the phone at the time, yeah.
So after the car backs up, does the car back up and then straighten it all, or just backs out of the parking spot?
The car is parked like this. He backs up with a little bit more room. We're standing right here. And then when he hits the gas, then he can swerve to hit us.
So he didn't drive forward and then have to turn left to go out of the parking lot. You're saying that the car specifically swerved to the right.
Yes.
Judge, the video you've seen, I can replay that, but it's just zoomed in, so I think you can get a better view if you think you need it.
I don't need it. I mean, I can see that. I will tell you if you think you need to play it for me, but what's clear to me is that there is a pole that is obstructing one of the poles from Kroger. But I can see the left side and also what appeared to be part of the area behind, which would seem to me whatever the vehicle, whoever was in the vehicle had more room to pull back and straighten themselves out. I can also see that the vehicle does head, to the extent there is a swerve, I don't know that I see a swerve. What I do see, however, is I do see an individual heading down the right side of that lane where there appears to be plenty of room to the left. That is what I see, but if you want me to see something different, then play your video.
Nope, I think that's good enough, Judge. You also say your husband wasn't injured at all, correct?
Besides spit all over his face and falling to the ground. No.
You also said something to the effect of, at the time, I thought it was the person. Do you remember saying that? when we were talking about the identification, when you went to the precinct and identified the person who you thought did this to you and your husband, or at least to your husband, do you recall saying, I thought at the time it was the person? And so you were wrong at that time, correct? So you picked somebody out of the lineup, right? And the police didn't tell you anything else, you just picked a person?
I haven't spoken to anybody until yesterday.
Okay. Nothing further, Judge.
Any redirect? It's one or two questions. I forgot to ask you the question I said I was going to ask you. So did the video that we watched accurately depict what happened in the parking lot? And second question is, and it's your memory though, that the car swerved slightly to the right to strike your husband. That's all.
No, thank you, ma'am. You may step down.
Cross. The Kroger lady?
May call your next witness.
Yes, Your Honor. Well, waiting, it's my understanding, in talking to the defense counsel, he would stipulate to the admission of people's exhibit number 1 as accurate video for the purpose of the examination.
That's correct, Judge.
All right, exhibit 1 is admitted. Come forward to be sworn.
Please take a seat, raise your right hand. Do you solemnly swear to affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth? See? Thanks. So you can put the last name for the record.
My name is Rachel Roberts, first name Rachel, last name Roberts, Roerts.
You may inquire.
Now, Ms. Roberts, can you tell us how you were employed back in October of 2024?
I was an asset protection specialist for Kroger.
Okay, which Kroger?
All of them, actually. I worked in the whole division.
And is one of those that you worked for the one on Plymouth Road in Ann Arbor, Washita County?
Yes.
Now, at some point in time, did the police come to you and ask you to give them something about what happened on October 28th of 2024?
Yes, I was requested a full video.
Okay, and where were you when you asked that? At that store or some central
I was
location?
in the store.
At that store. Do you remember who asked you to do that?
It was Detective Cross.
Okay. And how did you pull the video of whatever he wanted?
It was using our Orchid Fusion camera system. It's for inside the store, and then I had to pull video off Flash to try to see if I can get the parking
Okay, and what happened when that happened, when you tried to do that?
So I was able to pull inside the store, but the camera for outside the door wasn't working at the time.
Okay, so you were able to pull a video from inside the store?
Yes.
And did you give that video to Detective Ross? Okay, that's all.
All right, a couple follow-ups.
Yes.
You said that the camera system on the outside of Kroger wasn't working at the time.
Yeah, the camera was under repair with technology. We had to put a service ticket in for it.
When you say under repair with technology, is technology a company or
Yes, it's within like the division's little group.
technology is that owned by Kroger?
Yes.
How long had that camera been down?
It was down for about 3 weeks because they did a full reset within the vestibule. So a lot of the cameras got knocked out.
What does that mean? I don't.
Basically, they moved everything around. So like the shelving, that's when you walk into the main entrance, there's like a big shelving display. And then they had to move a bunch of tiles on the floors. So they had to use ladders to get to the ceilings as well to mess with the lights, and they knocked out some cameras.
Okay. Were there any cameras outside or in the parking lot?
Yes, there was a camera straight to the parking lot in the middle. There was a camera to the right, and then the camera that I needed was actually right outside the entry door. That's where they see.
Well, I'm a little confused. So, and it may just because I didn't understand your testimony, the cameras that got damaged while the things in the vestibule were being moved around.
Yeah, it was the first camera right when you walk in. It was right to the ceiling. So like, let's say I'm walking into that door, you look up, it was that camera that faced out. That one was damaged.
And that is the camera that would have captured the incident.
Yeah.
So there aren't any cameras like on the pole outside in the parking lot.
No.
I'm all set, Judge.
Thank you, ma'am.
Yeah.
All right.
Ready to go home then.
All right,
Back to
we're all set. Thank you. You may shut down. Next witness.
Thank you. Jonathan Kroger.
Yes, come forward and be sworn.
Raise your right hand. You solemnly swear to affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth, so help you God. State your very first and last name, record, please.
Cedric Michael Ross, MICHAEL
Harry Manquire.
And how are you employed, sir?
I'm a detective with the Ann Arbor Police Department.
How long have you been a Ann Arbor detective?
6 years.
And at some point in time, were you, pardon me?
Detective for
2 years. At some time, were you asked to be in charge of the investigation of the incident that happened at the Kroger parking lot on Plymouth Road in Ann Arbor on October 28th of 2024?
Yes.
When did you get involved in that investigation?
I was assigned that case to investigate.
Was it that night, the next morning?
I believe it was the next day.
Okay, and you remained the officer in charge.
Correct.
Now, the video we were watching, you were in court while the video was played, were you not?
Yes.
Okay, where did you obtain that video?
Yes.
Where did you obtain that video from?
I obtained that video from Orange Theory Fitness, which was a fitness studio that pointed right what they said that.
Okay, is that in the same shopping area as the Kroger?
It is.
Is it, how close is it to the Kroger?
I believe it's maybe one or two businesses to the east of the front doors of Kroger.
But that's where you got that video?
Correct.
Okay. Now, as officer in charge, did you ask the complainant and his wife to come down to help identify who the suspect might be?
Yes.
Could you know when that happened how long after the incident?
I don't recall specifically, but I believe it was within a week.
Okay. And what was done as far as having them help identify the possible perpetrator?
I compiled a photo lineup. I had another detective administer the photo lineup to them as I sat in. Sure.
Okay. You had a suspect that was in the lineup?
Yes.
Is that why you did not conduct it yourself?
Correct.
Okay. But you observed the lineup?
I did.
And did you observe Miss Yuling Lin observe the photo display?
Yes.
I had you as marked as People's Post Exhibit number 2. And ask if you could tell me if this piece of paper is.
This is the photo lineup that I put together.
Okay. And is the defendant in that lineup?
Yes.
Are the defendant, are we talking about somebody in court today?
Yes.
Could you identify who we're talking about?
Yeah, he's sitting right there with the orange photo.
Could may the record reflect he identified the defendant, Anthony Hamilton?
Without objection, record shows will reflect.
Thank you, Your Honor. And what happened then when Ms. Lynn observed the photo lineup?
We showed, well, the other detective showed her each individual photograph and went through with her to see if anyone looked familiar to her as being a suspect.
And what happened?
She selected Anthony Hamilton, said that he looked familiar and that she was 70% certain that it was him.
Okay, and is Anthony Hamilton the defendant?
Yes.
Okay. What photo was it? In the exhibit I've given you, what photo was in that exhibit?
That's more number.
Okay, so she said he looks familiar and about 70% certain that's him.
Correct.
Okay. Now, at some point in time, did you also have a chance to investigate the 911 tapes involving this case?
Yes, but I did not listen to the call.
Okay, not originally, but have you since?
Yes.
Okay. And in the call, was the license plate of the vehicle given to the 911 operator?
Yeah, that's, I think, straight here, sir.
Excited utterance, Your Honor.
Well, he needs to lay a foundation for that, then. You just can't assume a 911 call foundationally constitutes a excited utterance.
I think Miss Lynn did do that. The husband was almost run over. She claims that was just before the backing up incident. Was excited, was calling, got spit in the face and was calling the 911.
Well, herein lies the problem of why we don't have the actual complainant witness. I don't recall the complainant specifically saying that her husband made some excited utterances or laying that foundation. I know that what she described and said that her husband said, but she didn't explain how he said that and laid the proper foundation to get the.
Why is the license plate hearsay at this juncture?
For this witness, because he's watched the video, or I'm sorry, he listened to a call and he's relaying what was stated in that call.
But was it really for the truth of the matter asserted or for what was said and what they then did?
Well,
going to his state of mind as for the truth of the matter.
Well, I would argue that it's for the truth of the matter asserted because Brother Counsel wants us to believe or wants you to know that what the license plate was and actually if it was given. And also the best evidence of that will be the 911 call itself.
Maybe. Well, when I'm not necessarily I don't know what I'd be accepting for the truth of the matter of what, if you're saying it's hearsay.
That the complainant gave the license plate and what that license plate is. I'm assuming that's what Brother Counsel is going with the question.
For the truth of the matter of what the license plate is. And your response to that, to the extent that it is hearsay.
But there was an excited utterance was given to 911 after a near death experience, after an almost accident and being spit in the face and confronting an individual.
Since I don't know the next questions, I will just indicate that I'm going to the extent that it is hearsay, that it's being offered for the truth of the matter that's asserted, which is what the number is, I guess, then I would consider that at least based upon the testimony that I have at the time that the call was made, that it's a cited utterance, the individual is observing something as they're reporting it, which was the testimony of the first witness. However, I'm not sure that it is hearsay, so I'm also giving a provisional ruling that this evidence may be admitted for the purposes to show state of mind as to what the officers then did next. So.
You indicated that you did hear a license plate over the 911 call.
I believe so.
What did you do with the information about the proposed license plate number you heard?
At that time, nothing, because the vehicle had already been identified in the report. So the 911 call came after that.
Okay, did you ever learn what vehicle matched the license plate number that came over the 911 call? Whose license plate that was?
Yes.
Objection. That's now, I don't know to what extent he has done this investigation to find out what license and the driver or the registered driver is associated with. I don't know where that information is coming from. I don't know if a partner told him that. I don't know what steps he took to find that information personally. It lacks foundation, and it sounds like hearsay.
Response.
If the information as to the license number is allowed in, then I think he's allowed to say what the investigation of that license number led to.
Well, just because you frame something as a part of an investigation doesn't make it per se admissible. And we're not talking about information he got from the 911 call. We're talking about information that he obtained some other way that hasn't been explained or made a foundation.
You get, sir, so I'm understanding just you get a license plate number and then use some tool, I'll put it that way, available to you to identify that license plate number and what it's attached to, or the vehicle that it's attached to. Would that be correct in summary?
Yes.
Well, I'm gonna, I mean, quite frankly, within a matter of minutes, I can get a certified record if I know the number, and we can be done with this whole argument, because it seems rather silly to be arguing at this point in time. I'm gonna overrule the objection. I'm gonna allow him to testify as to what he did and what he discovered.
What did you discover as to what car that license plate belonged to?
Belonged to Cynthia Harrison.
Harrison?
Or, I'm sorry, yes, I think it is Harrison.
Do you know her relationships to the defendant?
I believe it's her mother. It's his mother.
Okay. Now, at some time, did you go to Kroger to try to get a tape from Kroger?
I did.
Do you know how long after the incident that occurred?
I believe that was also the next day.
Next day. And you heard Ms. Roberts testify, she gave you a tape.
Right.
Do you have a copy of that here?
Yes, it is on the flash drive.
It's plugged in already? I wonder if we might. I want you to come.
Yeah. Go ahead. Oh, hang on.
Thank you.
You're welcome. You know which one it is?
Oh. Okay.
Yeah, play.
Play.
Just click right.
Click okay. And did you have a chance to review the videotape that you were given?
Yes.
What did you see on the videotape?
I saw the suspect enter the store, which you could see his face a little bit better on the store video. Compare that to his SOS photo and determine that it was the same person.
So I wonder if I'll hit play and tell me if you could tell us if that shows what you said it shows. And if we need to fast forward, you'll have to come down and do it. The record, we're sort of fast forwarding. I remember the time. Right there. That was it. Back to that. Okay. Okay, now we stopped the video. This is video which is marked as People's Proposed Exhibit number 3. And what do you see on the video now?
The suspect involved.
Now, how do you relate the person coming through the door, as we see here on People's Proposed Exhibit number 3, with the incident?
Based on the other video.
What do you mean based on the other video?
So the Orange Theory video, where you can see the description of the individual that was involved in that video on the story in Kroger.
And how about time? Is there a time coordination between the first video and this proposed exhibit number 3? I mean, was that done at all, or is it just a closed description?
Yeah, it was a closed description, and I think the time, I don't think the time on the Kroger video was the accurate time of day. I don't recall, but the videos had lined up.
Okay, I want to hand you what's been marked as, by me, as proposed exhibit number 4.
Can I take a gander?
Oh, I'm sorry. Yeah, I'm sorry.
This is the photo, right? On the photo log.
I have shown this to the defense counsel. Now, this is a case where smart people proposed exhibit number 4. How about that proposed exhibit is?
It's a side-by-side of the Kroger video and the suspect's SOS photo.
The Kroger video, I mean, the person, is that photo taken right off of the video?
It was a screenshot.
Okay, I move for the admission of both exhibits 2 and 4, Your Honor, and 3.
Any objection or water to any of these?
One question. The photo, there's 2 photos on the exhibit that you have, correct?
Yes.
The one photo that is a portrait, is that the same portrait that was used in the photo array?
The one on the left? Yes.
Okay. Then I have no objection.
Exhibits 2, 3, and 4 are admitted.
I have no further questions, Your Honor.
Cross-examination.
One second, Judge.
Yes.
I don't have any questions for this witness, sir.
All right, very good. You may step down. Thank you, sir.
I have no other witnesses, Your Honor. I move to bind over on the charge of great bodily harm and felonious assault.
Response.
So part of the reason why I asked, Your Honor, if you needed, or if it would be helpful to view a more zoomed in picture of this event was because I don't know to what extent a person can illegally try to hold a person in a spot, because what the proofs were did not rise to the level of a felony. And as Your Honor knows, the only way that a citizen can make a citizen's arrest or keep somebody in a place they don't want to be is if they've committed a felony in their presence. There was no felony committed, at least before the purported use of the car or the misuse of the car. So you have a situation where even in the video, you can hear, for purposes of the exam, I'll say my client is yelling about, get away from my car. Why are you at my car? He is observed trying to leave. The complainant, and I don't think his wife, I think it was just the complainant, physically stops him from trying to leave a couple different times. And then that's when you see my client drive away. Now, if you zoom in closer, I don't think that this swerve that the first witness testified to is that purposeful. What you see is the car back straight out and then drive forward and straighten out as they're going toward the main road. There's no reason, if my client was trying to actually run this guy over, as it was characterized as, that he couldn't have just done it. If he was trying to turn the wheel, he just turned the wheel and he would have ran him over. Also, the lack of injury, as you know, for GBH cases, an injury is not required, but an injury can be used to show the defendant's intent to do the specific type of harm, specifically the great bodily portion. But on the flip side of that, if there's no injury and the witnesses testified that my client backed out and the complainant is right behind him, which of course he could have just injured him then, there's no injury. And then there's no injury even after the fact with the driving forward, I would submit to the court that that's proof of a lack of intent to do great bodily. And the last thing I want to say is I've been analogizing this situation to a woman leaves the gym and a person or man wants to get this woman's phone number, and the woman shows that she's not interested. And she's walking to her car, the gentleman follows her to her car, and then attempts to not let her leave, standing in front of her, behind the car, standing in front of the car. I don't know to what extent the woman has to stay there, or if she decides to floor it, if the gentleman who's trying to keep her in one spot is in front of the car and she tries to floor it and he has to jump out the way. I don't think that constitutes a crime. And I think from the video, from the complaining witnesses, or the witnesses' testimony, I think that's pretty much what we have here. Insofar as somebody trying to hold somebody at a place they don't want to be without any type of legal basis to do that. And you see that person repeatedly yell about trying to leave, yell about being stopped, and then you see them try to get away. So I don't think that rises to the level of a GBH. I think this could have been charged differently, but I think that GBH is a stretch for these specific facts and circumstances, Judge.
Response. So the video may have been somewhat ambiguous because it is pretty far away, but the testimony of the witness said that the car swerved to the right where we were not in the parking area, but in the parking space yet, to have to go into the parking space and actually struck the man and knocked him down. He got hit by a car, aimed at him. I think if you hit someone intentionally, that would, at least we have GBH. And then FA is, of course, a lesser offense, not included, but just using the car. We just have a road rage type of activity here that began before we had spitting in the face, being upset because the police were being called over that incident, and then quickly driving away. People think that makes the element in the video, and for the testimony of great bodily harm, and then identifying the defendant, I think we have enough for probable cause to believe he's the one who did this. So I would move to bind over as I've asked. Thank you, Your Honor.
Court, having heard the testimony in this case, what is clear, so we can clarify the court's view of the video. While the video, there is a block to it, I think the critical part, coupled with Ms. Youngling's testimony, is that it may be indeed a question of fact as to the swerve. Irrespective of that, what is clear is that that vehicle is clearly on the right side of that lane, to the extent that then the individual, Mr. West, is identified by his wife, had to leap out of the way, and you hear his exclamation. So while it might be true that frankly, I don't buy defense their picture of what happened when the vehicle backed up. What happened when the vehicle backed up, had it wanted to straight and avoid the individuals that were in that lane, including Mr. West, it could have backed up further, headed on a different angle and gotten itself out going down that left side. And that's the part that the court is really focused on. That vehicle stays to the right side of that lane where Mr. West is. And then you see Mr. West, as you see in the poll, you see him kind of go back toward the car. So, and that video from this court standpoint carries great weight as to what that vehicle was doing, what the defendant is identified as the person at the scene. And there is at least enough evidence for the court to believe that the defendant was indeed the one that was driving that vehicle. It's clear to the court that the people have sustained their burden in this case of the necessary elements as to both offenses in this case, both the assault with intent to create great bodily harm less than murder, as well as the other offense of felonious assault. It is, I will address it, but I don't think that it's absolutely necessary in this court's part. I don't think an individual where there is some type of altercation, remembering that the spitting in his face occurred, the spitting in his face and what's occurring between these individuals has occurred prior to the point in time that he is now calling the police, asking for, that he's calling, basically asking for some type of police assistance, but then also requesting and standing where he's standing to have this individual wait. I don't think that was any type of false imprisonment. I don't think it was anything other than Mr. West attempting to try to get this individual to stay there until the police left. And really has no bearing on or any effect on the rights of the defendant in this case, because he actually did leave. He was free to leave. He did leave in the case. And again, I don't think it has any bearing on that. I would also note that I do find the testimony of Ms. Yulin very credible in terms of what she saw. I don't think she was attempting to try to exaggerate things, but also she was testifying in essence about two events that occurred that night that involved, well, really three, but two specifically would have involved her husband being hurt. So certainly, and I don't say this with any disrespect, that there was some emotion involved in that, but also the spitting on his face as she's observing it. She's testifying about that. So the court would find, based upon all of that, taking all of the evidence into consideration, that the people have indeed sustained their burden and would bind the defendant over to stand trial on the account of assault with intent to do great bodily harm less than murder, as well as assault with intent or assault with a dangerous weapon, the felonious assault. I just want to be clear, while they're not the same, the felonious assault and the assault with intent to do great bodily harm less than murder, Mr. Prosecutor, are those all the events that occur in the parking lot itself?
Yes, Your Honor, that's the alternate, depending on what the fact finder decides, alternate results that it's available. FA is not a necessarily lesser included, so.
Exactly. Okay, I just wanted to make sure it didn't include a separate event that was testified to regarding the vehicle coming at Mr. West at another location during that night.
No, Your Honor, it is the same.
That same incident.
Yes.
Okay, so I will bind the defendant over. The people have sustained their burden on that. I will also bind the defendant over on an additional charge of assault with a dangerous weapon. That being the event that occurs in front of the store that Ms. Yulin testified to, where the vehicle approached and that Mr. West had to extend his hand. So I will add that count 3 of that felony. I will also add a count 4 of assault and battery, the simple misdemeanor for the spitting in the face of Mr. West. So therefore, the defendant is bound over to stand trial on counts 1 and 2 as stated in the original complaint, as well as count 3, which the court is adding of another felonious assault, specifically with reference to the initial event. And then also a misdemeanor charge of assault and battery for the spitting in the face of Mr. West. So defendant is bound over to stand trial on all those charges.
If we do the arraignment here, correct?
Yes, that is correct, counsel.
So we would waive formal reading to the extent Your Honor has not already read it formally in the standing.
All right. Defendant having waived formal reading, standing mute, the court will enter a not guilty plea as to all 4 counts. Pretrial in this matter will take place
October 9th at 1:30 with Judge Slay.
October 9th, 2025, 1:30 before Judge Slay. Is there anything as to bond in this?
Yes, Judge.
Go ahead.
So obviously my client is here and in custody. And the last time we were in front of you, he was not. And I think that Your Honor probably is aware of the factual allegation as it relates to why Your Honor wanted to address bond. A couple of things though. I was a little confused about the court's instructions, not because of anything your staff did, but I had never seen a person be expected to report to jail without a specific order. But regardless of what I saw, when I explained the situation to my client, and he explained like, hey, you may want to report earlier than Tuesday. He was more than willing to do that. And I can't say that would have been the case in most clients I have, honestly. So I think that counts for something insofar as he's willing to come to court when Your Honor doesn't even explicitly say it, but it's expected for him to come to court. So I think that goes in his favor. The other 2 more important things though about bond, Judge, is that my client, I think Your Honor is familiar with him from past cases. He receives services through this county. One of those services is the use of a support dog. There is no one else to care for this dog while my client is in custody. My client is, of course I have pictures I can show the court. I think that you are willing to take my word for it, that his relationship with his dog is probably one of the most important relationships that he has with any being on this planet. The second thing that is also important and relevant to bond, Judge, is that he also receives a housing voucher, and he will be disqualified from receiving that voucher if he is in custody for more than 30 days. So with those 3 things, but primarily 2 things being in mind, I would ask that Your Honor not necessarily revoke his bond outright, but consider a progressive sanction, and that being tether with house arrest or some type of restricted hours, so that he can still take care of responsibilities, but may not necessarily be allowed to go and come and go freely as he has been allowed to previously. I have not spoken to the complainants or anybody involved in the new allegations. But what I've been told is that regardless of what the police agency investigating that does in terms of submitting a warrant request, I've been told that there's not going to be any follow-up with the complainants and that this was actually a misunderstanding. They know my client and he frequents there often, and he hasn't even been trespassed there, as far as I know. So I would just ask Your Honor to consider those things in relation to bond and not necessarily just revoking it and put him in remand status until his trial.
I don't need a response. As to the first issue regarding the defendant turning himself in or not, the court had received a bond violation report from the Ann Arbor Police Department. The court reviewed it the court, based upon that report and based upon the bond conditions that the defendant was under in this particular case, decided to issue a warrant, no bond. There doesn't need to be another order because he was going to be taken into custody one of two ways. I think it was your office and maybe you that called my office to determine what he should do. I don't think any specific direction was given whether or not he should turn himself in. However, there was a valid warrant out for his arrest. Quite frankly, from my position, whether your client had turned himself in or not, or whether he just walked in today, I was going to take care of it. So it really, 6 of one, half dozen of another as to what he did. Maybe he spent a little bit additional time while in jail. But that's it. But what is clear to me is that the incidents that occur that are at least alleged in the Ann Arbor police report there, that case number being 2540579, which led to the issuance of the warrant that this court issued, show an individual that, frankly, from the court standpoint, can't follow the court's orders, and also would, in this court's mind, be someone who is dangerous to this community. There's not an adequate way in which to control it. While certainly a home confinement tether might be something that the court would consider, I'm not sure that that tether would keep him in. And then once he's out, what it seems to me in looking at these and other, but these particular cases, is that he has some tendency to then engage with people and does engage in behavior where he is attempting to threaten and or injure people. So I certainly take all of that into consideration in this case. And given all of that, in this case, in the court finding that the defendant has, or at least it appearing that the defendant has indeed violated his bond conditions of this case in an assaultive fashion on an assaultive case, the defendant's bond is hereby ordered revoked at this juncture. So.
Thank you for your consideration, Judge.
Thank you, folks.
Appreciate the court's forbearance as I stumbled my